Municipal court.
When they start going, you know, take it long.
All done? Are they ready?
No, not yet. I'm just telling you that. He
We're in
will.
the court.
He will.
Is that really what happened? I'll hear it. I'll get ready. I even have a hair thing on. I was at the hospital, my mom's been at the hospital. It's called me right now. Disappear. I'm sitting right in your chair. I'm sitting there.
Have your attention, please. All rise. Lawrence County Municipal Court is now in session. The Honorable Donald R. Kepler presiding. All those having business before the court draw near and you shall be heard. God bless the great state of Ohio and this honorable court. You may be seated. State of Ohio versus Haley Early. Haley Early at the Lawrence County Jail.
Good morning, Haley. Can you hear me?
Yeah. Can you hear me?
I can. Well, I'm very disappointed.
I messed up.
And I understand it was over a vape and a phone.
Yeah. I made the wrong decision to leave because I thought I was going to get in trouble anyway, so I made a really bad decision.
Yeah. You had a free apartment,
Um,
free food, get to be with your kids. They provide you with daycare while you go to classes. I mean, that's worth a lot. A
if
lot.
they were willing to let me come back, I would love to come back because
I would love to get you back. Do you know, I'm sure you don't even know this, they have a waiting list to get in that facility. And I pulled strings to jump you over a bunch of other people to get you in that facility, and then you pull this.
I know I made a huge mistake. I wish I never left.
I wish you never left too. You know who I really feel sorry for? Your three kids. Your three kids who are 5 and under, and your grandmother who's trying to raise 3 kids that are 5 and under. How old is she?
70 something. I know I messed up. I really did. If I can get in somewhere else or something, I'm willing to do that because I made the hugest mistake in my life.
Well, how about, I'm going to try to get you back on Project Hope, but I don't know that that's a possibility, but how about stepping stones?
If I get back on Project Hope, I would love that, but either or, I guess, because I have work, I've done it for kids on the 29th and everything, so.
I'm looking at Ron, it's Ryan, right?
Yes.
Is that a possibility? She's got 3 kids.
Is she Ohio resident?
She grew up in South Point, right? You grew up in South Point.
No,
But I think of late, she's been living in Huntington. But, I mean, she's a metro person. She's back and forth across that river like it's nothing. And it is nothing. There's bridges that just let you go back and forth. She goes back and forth as she pleases. Right?
if I get another opportunity, I'm not gonna mess it up this time, because I did over, it was stupid, but I did it over.
Yeah, I agree with that.
Because I'm fine with like one.
Okay, so I'm going to start working on this. I'll have you back later in the day, but I'm going to have to pull some strings again to try to get
Please,
you.
I promise I will let you know if I can get back in there or somewhere else.
Well, you know what's going to be good about that? I have to wait and see, because you promised me before and you didn't come through.
Right.
So it's
I understand.
time is going to tell the story. And, I mean, you're young, you've got these 3 kids, and we, you know, I'm gonna start preaching again, but you're important to me. I want to see you get things together, but these kids don't have a choice.
I know, and I wasn't.
You're dictating to them what their life is going to be like, and they've got, you know, they're saying the kids now could live to be 100. We're talking about 90, 95 years, that what you do has an impact on their life from now on.
I promise I will not let you down this time. I learned the big mistake of doing that over a phone. I don't need a phone anyways. My kids
You
are
can have,
still
they were going to let you have a phone after you're there 30 days. You couldn't go 30 days without a phone?
I don't know why, I really don't.
Okay. All right, I'll see you back later today sometime. I don't know when it'll be, but we're going to be pulling some strings between now and then, try to get you back somewhere.
I promise I will not let you down.
This is really important. All right. Okay, that's all at the jail now. We'll come back to you at the jail. We've got several other people in there, but we'll come back to them later in the docket. Thank you.
Okay, thank you.
Okay, so we'll come back to Haley. I've got a text about her right now. I was waiting to hear what her attitude was, because I wasn't sure what it was going to be. Ryan, does she have to have Ohio Medicaid before you guys can take her? Or?
She would need to, if she is on West Virginia Medicaid now, that's okay as long as she was planning on residing in Ohio once
She grew up in South Point. Went to South Point High School.
Can I call and talk to her?
Yeah, she's at the jail. I'm going to first try to get her. Try to get her back in Project Hope, but I don't know if they'll take her. They're very strict. So it may be once you're one strike and you're out. I don't know if they give more than one strike. So, but I'd like to have you as a backup. Okay, we'll come back to Haley later. Okay, the first thing, we just got 3 cases for review, so people that have got that, your name's going to get called, come up to the table to the right, and I'm going to review your files. Call the reviews.
Matthew S. Smith, Justin B. Casey, Christopher Smith.
Christopher Smith?
Matthew Smith.
You're Matthew?
Yeah.
Okay, Matthew Smith. 21,692. 15,457. 14,553. 14,665. 12,627. Okay, what's going on with you now?
Everything's good. I'm waiting for a couple surgeries. Just behaving.
Okay, you've got community service to do, you've got restitution and fines to pay.
Yep, I'm
The main
planning on
thing
paying
first
it.
is restitution. Are you making a payment today?
Yes.
How much are you paying?
Let's pay 20 on there.
And you've got community service to do.
Correct.
Okay. When are you going to do some community service?
Well, I have a couple surgeries coming up. I thought I had 6 months to do it, so I was trying to maybe get this surgery out of the way. That's what Major had said to me about my community service. I even asked him about that this morning to make sure that I was right on that.
I guess your community service is all on the last case.
Yeah, it's on the last case, yeah. That's 30 hours.
5 days of community service.
Yeah.
And for everyone, we're giving double credit on April 27th. It's a Saturday, it's a township cleanup day, and May the 4th. So 2 Saturdays in a row, you get double credit. So you get 2 days credit for doing one day on those
That's it.
Saturdays.
April 27th and May 4th?
Yes, sir. Okay, see the clerk to make your payment,
All right.
and I'll give you a new date. May 24th.
All right.
May 24th, 9 a.m.
Thanks, sir.
You're welcome. See the clerk. Justin Casey,
Yes, sir.
22-2460.
Your Honor, if I may, he turned 22 hours of community service in this morning.
Okay.
He still leaves him 8 hours left to do.
And you have been going to Southern Hope, you still there, or
I graduated their program. I work every day at the Facing Hunger Food Bank.
you're working where?
I work at the Facing Hunger Food Bank Monday through Friday.
Oh, in Ironton?
Well, we're out of Huntington.
Oh, okay. There's one similar to that named in Ironton.
Not sure what that one is.
Okay. You pay anything on your fines today?
I will be paying it all the way off Wednesday when I get paycheck. I think it's $410, Your Honor.
Okay. If you get things finished, you won't have to come back for your next hearing.
Okay.
So I'll set that. May 31st. If you finish it up by then, you don't have to be here. 9 o'clock, May 31st. Good job.
Thank you, sir.
You're welcome. Christopher Smith, 22-741. I'm showing he has paid his fines, he still has 3 days of community service.
That is correct. He's been at community service last week, I believe.
Okay. He's got 7 days before warrant will issue. Okay, that finishes the reviews. We're about to start the arraignments now. So anybody that's got an arraignment needs to come in the courtroom and have a seat.
Arraignment, warrant, hearing, these people are now.
And Kim, I decided you didn't, she was very remorseful, wants to go back to treatment, so
I get it.
it was necessary.
Thank you, just let me know.
Okay, so the next hearings are called arraignments for new cases or old cases where a warrant got issued. If you missed a hearing or something happened in your case and you came in to get the warrant withdrawn, you're going to get called with these cases. If that happened before and you didn't check in, you need to go check in with the clerk, because otherwise we won't know you're here today if you missed a hearing before. When your name's called, come up to the table to your right. Please don't talk. Ma'am, don't talk while I'm talking. These people need to listen, and you need to listen too if you're here for this. You have a right to remain silent. You don't have to say anything. If you do say things, it's on the record, it can be used against you. You have a right to have an attorney, to have one appointed. You have a right to have bail and to make the state prove any charge against you beyond a reasonable doubt. If you enter a guilty plea or a no contest plea, you're waiving those rights. You should not do that if you don't understand the proceedings. If you want to talk to a lawyer, if you want a trial, or if you don't know what to do, you should enter a not guilty plea. That's always the safest plea, and it preserves your rights. Call the first case.
State of Ohio versus Roger Frizzell. Case number TRC 24-782, A, B, and C.
Are you Roger Frizzell?
Yes, sir. Yes, Your Honor.
Mr. Frizzell, it's alleged on April the 16th at 4:23 p.m. in Union Township, you were operating a vehicle while you were under the influence of alcohol. And it's alleged that you took a breath test and tested 19 on the breath test. So there's some numbers with the breath test that are important I'm going to explain to you. The first is the per se level. So I'm going to drop some of the decimal points just to make it easier to understand. The law in this state and most states is if you test 8 or higher on the breath test, there's a presumption that you're impaired by virtue of that test score. But in order to get the presumption of impairment, the state has to show compliance with the rules. There's health department rules about giving the test. They have to show the machine was calibrated properly and they follow the other rules for giving the test to get the presumption. So obviously 19 is higher than 8, so you would be over the per se level. Now, there's another number that's important. That's 17. If you test 17 or higher under Ohio law, it's considered a high test score, and that raises the minimum penalty. So even though this is a first within the look-back period, there's going to be mandatory jail on this if you're found guilty. The maximum penalty, they have it down as a second offense, but it's actually the first within the look-back because I'm showing your last conviction was in 2009. So that's more than, there's a 10-year look-back period now, so that's beyond that. So it would be considered a first offense, but still, the maximum is 6 months in jail, $1,075 fine, 3-year license suspension. That's the most the court can impose if you're found guilty. With a test score of 19, the least I can give you if you're found guilty is 3 days in jail and 3 days in a treatment program. And that 3 days in jail is what comes along with a high test score. There's no mandatory jail on a first if you're below 17. If you're above 17, there's mandatory jail time of 3 days. And the minimum license suspension is 6 months. The minimum fine is $375. Do you understand that charge and the possible penalties?
Yes.
You've got 2 other charges. Driving with a license that was not reinstated. In other words, the state's saying you got suspended before, the suspension was over, but you never reinstated your driving privileges. That is what's considered an unclassified misdemeanor. The maximum penalty is 500 hours of community service and a $1,000 fine. There's no jail time on it, but there is community service and fine. And then your third charge is either a stop sign or a yield sign that you ran through that. That's a minor misdemeanor. Maximum penalty is a $150 fine. So you've got 3 charges. Do you understand the 3 charges?
Yes, yes, Your Honor.
Do you understand the rights you have as a defendant?
Yes.
How do you wish to plead to these charges?
Not guilty.
Do you want a lawyer appointed?
Yes, sir.
Do you have a job?
I'm on Social Security. I just retired a few months ago.
Do you get a pension from your retirement?
No.
Just Social Security?
Just Social Security, yeah.
I'll appoint Mr. Stratton to represent you, and he's here, so we'll have him come in the courtroom. Roger Frizzell, Mr. Stratton, entering a not guilty plea for him. The most serious charge is a first offense OVI with a 19 test score.
Okay.
Not guilty plea is entered. We're looking at, we could do the 10th of May, the 10th or after May, any date after that.
10th will be fine, Your Honor.
May 10th? Yes. May 10 will be the next hearing. It's going to be a pretrial at 10 o'clock. Mr. Frizzell
No.
can sign a $2,000 signature bond.
State of Ohio versus Ladana Walter.
Ladana, yes, sir.
Ladana Walter, case number TRD 24609, A and B.
Ma'am, you're Ladana Walker?
Yes, sir.
Ms. Walker, this is an old case.
She had successfully completed the recovery center, and she is now following up with the outpatient office in Huntington.
Okay, looks like she finished February 7th. This is a case from December of 23, December 16th, 2023. It's alleged that you were in Rome Township driving a vehicle while you were under the influence of alcohol or drugs, and that this would be your second offense, that you had a prior conviction in 2023. It's alleged that you submitted to a urine screen. That may be available now. It takes several weeks to get the results, so I don't know if the results are back yet or not. I don't have anything in the file. On a second offense, the maximum penalty is 6 months in jail, $1,625 fine, and a 5-year license suspension. The minimum penalty is 10 days in jail, $525 fine, and a 1-year license suspension. You're also charged with driving outside your lane. That's a minor misdemeanor. Maximum penalty is $150 fine. Do you understand these charges, ma'am?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you plead to these charges?
I guess. Not guilty.
Do you wish to have a lawyer appointed to represent you?
Yes, sir.
Do you have a job?
I have 2 jobs.
What do you do?
I work for Claire's. I travel to the surrounding Walmarts, CVS's, Kohl's, Walgreens, and I restock the Claire's product. And I work for SAS Retail Odyssey, and I go in there and do Kroger resets.
Okay. What our Supreme Court tells me I have to do is determine your gross annual income. So, do you file an income tax return?
Yes.
Do you know what your gross annual income is?
I don't.
Well, I'm going to have to figure it out, so you'll have to help me. What do you make gross in an average week or bi-weekly, however you get paid?
For Claire's, I make about $750 every 2 weeks. And then I just started the SAS retail job, so this will be my second paycheck this coming Friday. My first paycheck was only like $137, but it was just short hours. This next paycheck should be around like $500.
A week or 2 weeks?
2 weeks.
Do you have dependents? Do you have anybody that's dependent on you for their income?
No, I don't have any kids.
Okay, so you're making about $1,250 every 2 weeks between the 2 jobs. Do you have any money saved?
No, not really. I have a car payment that I pay. It's $200.
It doesn't matter. I know people want to tell me about their car payment, boat payment,
I roughly have
child
about,
support. It doesn't matter. It just matters what your gross income is.
I roughly have about $375 in the bank.
Okay, you're right on the border. I'll go ahead and appoint you since you just started this job. Mr. Smith, I'll appoint you.
Yes.
And this may be one, on the ticket, and they may be stuck with it, but there's also a prior conviction alleged in 2015. So it could conceivably be a third offense. I'm entering a not guilty plea for her. May the 10th or after, anytime after May 10th.
10th is not good, the 17th, or any time after the 17th, Judge.
May 17 will be the next hearing. Pre-trial, 10 o'clock. She can sign a $2,000 signature bond.
Thank you, Judge.
You're welcome.
State of Ohio versus Ken Dempsey, case number CRB 24-161.
Sir, are you Ken Dempsey?
Yes, Your Honor.
Mr. Dempsey, it's alleged in case number 24-161 that at Perry Township, December 24th, 27th, and 30th of 2023, you issued checks number 142, 143, 144 in the amounts of $286.93, $117.87, $106.92 for a total of $411.72 to South Point Food Fair, knowing they would be dishonored. So the charge is passing bad checks. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, Your Honor.
Do you understand your rights?
Yes, Your Honor.
How do you plead?
Not guilty.
Do you want a lawyer appointed?
Yes, Your Honor.
Do you work?
Yes.
What do you do?
I'm inside sales for Applied Industrial Technologies.
All right. What's your gross annual income?
Around 20,000, 18, 20,000.
Okay. I'll appoint Mr. Thompson. Entering a not guilty plea for you. This is Ken Dempsey, Mr. Thompson.
Hello, sir.
He can sign a $1,000 signature bond.
Sign this right there.
Reading glasses. Thank you, sir.
May 20th, Mr. Thompson, that's a Monday.
That is fine.
May 20th,
Thank you, sir.
You're fine.
be a pretrial at 10 o'clock.
232-9373.
Call me on Saturday. Okay. At 1 o'clock.
At 1 o'clock?
Yep.
All right, okay.
Thank you.
You're on.
State of Ohio versus Jory L. MacArthur, case number CRB 24-139.
And sir, you're Jory L. MacArthur.
Yes, sir.
You received a copy of this charge.
Yes.
The charge alleged is aggravated menacing, and it states that on March the 6th of 2024 in Perry Township, you knowingly caused Amanda MacArthur to believe you would cause her serious physical harm to either her property or person. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. You understand the charge filed against you?
Yes, sir.
You understand your rights?
Yes, sir.
How do you plead to this charge?
Not guilty.
Do you wish to have a lawyer appointed?
Yes.
Are you working?
Yes.
What do you do?
I work for Heiner's. I'm a
Heiner's?
route driver.
Paid by the hour?
No, commission and base salary.
Okay, what's your gross annual income?
Probably 75.
Okay, you're not gonna be qualified then for a court-appointed attorney, so you'll have to hire your own.
Understood.
How much time do you need to make those arrangements? And I'm not setting cases till at least May the 10th anyway, so that enough time? Okay.
Yes, sir.
Okay, is this Amanda?
Yes, sir.
Okay, let's have her talk to the prosecutor.
Your Honor, if it please the court, I'm speaking with Amanda MacArthur, and she's the alleged victim in this. And this is alleged to have occurred back on March the 6th. And I'm told that since that time, apparently they were in the process of a divorce at that time. And since that time, the divorce has been finalized, and she says that their ability to get along has improved greatly. But we also believe that Mr. MacArthur might have started into some sort of counseling or something that's a good thing. They have a child together, at least one.
Yes, 1, 2
And
years.
so parenting's a big issue. She wants me to drop the charges. However, our normal procedure in a situation like this is to, while we do take those requests seriously, we also take what happens seriously. We want to make sure that that both parties are in a position where this won't happen anymore. And if Mr. MacArthur is taking part in some counseling, we would want to encourage that forward. So our proposal would be that we would continue this case with the idea that Mr. MacArthur would let us know what kind of counseling he's doing, come back and give us some reports, make sure that there aren't any further problems, and down the road, in the not too distant future, we would agree to dismiss the charges if it keeps up with the counseling and if the court costs are paid.
All right, Mr. MacArthur, what do you think of that?
I'd be happy to agree to that.
Okay, so let me explain one thing that means. What we're going to do is let you go to counseling. We're just going to let the case sit here for a while you do that. And then if things go well, no further problems, you complete your counseling. And, you know, I agree with the prosecutor. The main thing is that this kind of activity not happen again. I want to prejudge it, but I read the affidavit. You know, if it's true, that's pretty serious stuff. And it's not a way to deal with anyone, especially your wife, the mother of your child. And that's going to continue. I'm divorced myself. So, I mean, you can get a divorce, but you don't really get a divorce. Because you got, did you say a 2-year-old?
2-year-old, yes.
You're going to be joined at the hip for quite a while. There's going to be soccer, Little League, graduations. I mean, there's going to be all this stuff that's still going to, and for the benefit of your child, you need to get along and come to these things and be able to get along and not have conflict. I mean, you can have conflict, but not have the kind of conflict where it resorts to threats of violence. That's not acceptable. So, toward that end, I applaud you for going, because you've been proactive about going to some counseling. I think that's a good thing. But you have a right legally to say, no, I want a trial on this. And then the state would have to bring in their evidence, and I'd listen to it and make a decision, yea or nay. We're not going to do that here. And you also have a right to make the state bring the trial within a certain time frame. It's called speedy trial rights. That's your right to make them bring it within a certain time frame. We're not going to, you're in effect agreeing to waive the speedy trial because hopefully we're not even going to get to a trial. You're going to do your counseling in case it gets dismissed. We're not going to be back in here for a trial. Do you understand that?
Yes, sir.
And you agree with that?
Yes, because I want to do the counseling regardless, so.
Okay. So what I'm going to do, I'm going to put this off for about 3 months, let you go counseling, and then on the condition that there's no further problems, you keep on the counseling, and eventually we'll get this case dismissed, maybe at the 3-month level, but I need a report. Bring me something from the counselor. Where are you going for counseling?
It's a behavior. I have a behavioral doctor, Christina Rowe now, and then I go to Rock Hill Behavioral. It's at the school there, and I'm doing EMDR, which is a form of trauma counseling.
Okay. Bring me some kind of report so I've got some justification to say, yeah, he did it, and this isn't likely to happen anymore. That's what I need to show.
Yes, sir.
So let's go out about 3 months. So that's going to be in July. Mondays or Fridays better for you for your work schedule?
Friday.
Okay, so I'll set it for July 26th. That's a Friday. That'll be your next hearing. Okay.
Yes, sir.
And I'll set it as a pretrial, so I'll be looking for a report from your counselor then.
What's the date, Your Honor?
July 26th, 10 o'clock. And Mr. MacArthur can sign a $1,000 signature bond.
And we would also need a time waiver.
Yeah, you're gonna sign something, just what I just told you about waiving time, they got a document for you to sign that says you're waiving time. So the bond you're signing just says, I promise to come to court. If I don't, I'll pay a $1,000 penalty for not showing up. Just show up and you won't have to post any money. No.
He's gonna have some.
You don't, I take it you don't want a protection order under these circumstances. Okay, any questions?
Yes, sir.
Okay, that's all. I'm free to go.
State of Ohio versus David L. Fetty, case number CRD 24-140 and TRD 23-1820 A and B. David L. Fetty.
He's only getting trained on agreements. We don't have this.
Okay.
Well, he should have been arrested anyway because there was an outstanding warrant for him previously from, looks like from, well, maybe not. Maybe this is all arose at the same time. There's a traffic case from 23, and then this case, which has a 24 case number. He was served with a summons personal service on March 27th. He hasn't appeared, he's been called for. He was ordered to be here today. There'll be a bench warrant issued for failure to appear. Now, there actually was on the traffic matter, there had been a warrant issued on March 28th, so he's got 2 warrants now.
State of Ohio versus Anthony T. Spencer Jr., case number CRD 22-137.
Okay, this is on a theft conviction. There was a review hearing on February 6th of 23, so a year ago. Glad she didn't appear, got a warrant issued for that, and now you're here today. Do you admit or deny you missed your hearing on February 6th of 23?
Well, when I came in November, I had a court date in November. I had paid my fines, finished my program, everything I was supposed to do. My understanding was she told me that if I did that, I didn't have to come back to the next hearing. So,
well, I've got something that I think is a certificate of completion, but it's only it's like a half copy.
when I came that day, I gave you my certificate and I gave you the my certificate and the community service paper and all that stuff all in the same day. It was November.
Well, it says here completed September 13th.
That's when I graduated. That's when I graduated from it, but court wasn't until November.
Well, I think actually the hearing that you missed was in February, so that was before this. No, okay.
Yeah, I graduated in September. The court date was in November, and then the hearing was in February.
Do you know anything about this, Mr. Mayor?
I don't, Your Honor. I looked at the file, not the file, but the actual, in the computer. Mobac figures we didn't accept the completion letter because it wasn't a full.
I don't know if you took that copy or it's half of a page. You did pay your fines and you did do your community service. Did you find out there was a warrant? That's why you came in?
Yeah, so I got a new, I moved to Frederick, I got a new job, and I'm a manager. They did a background check.
And found it?
And found this, and so we called to find out about expungement, and they said I had a warrant.
Okay, well, here's what I'm gonna do to clear this up. You do a urine screen, if it's clean, your case is completed.
Okay.
Go with Mr. Major, he'll get the urine screen, and we'll complete it if you got a clean screen.
State of Ohio versus Shannon Boggs, case number TRC 19-404-4045.
You're Shannon Boggs,
Yes, Your Honor.
and Mr. Delauder is your lawyer.
No, sir, I have a little.
Well, it appears here you missed a pre-trial. And this was in 20, so it's been almost 4 years ago. Mr. Delauder's here. Oh, he withdrew his your claim. He requested to withdraw as your lawyer, so. And it was permitted, so it's already been an entry. So you got arrested. This is an old, they let him post at 1,500, it should be more than that. It's supposed to be 2,500. So what's your story? Why did you not appear? Well, first of all, do you admit you failed to appear back in June of 20?
I couldn't deny that, Your Honor.
It would be tough.
I would, absolutely not, wouldn't it? I was sick for 30-some days. I called to get a new court date. After feeling better a couple days, then I had COVID, tested positive for COVID. It was during this whole time. 2 family members passed. You did the estate of 1. It just felt, I have no reason, really. It just went on and on and on. I forgot about it. I went to your office well, several different times, as me and Missy had discussed out there, and never brought up.
Well, it's not her job.
Yeah.
Missy, you're supposed to tell people who got warrants, you gotta get in court. How would she know you got a warrant?
I just, around everybody, I never thought, I don't know how it fell through the cracks for this long. I really, honestly, and truly don't. And all I can do is apologize.
Well, you're just lucky you didn't
take
have
my
police
money.
contact, but eventually you did and got arrested, right?
Every day I'm with them. It never was brought up. 2 of my best friends, it just never was brought up that I had a warrant. I was totally in shock.
Unless they're gonna check, they wouldn't know. Because it doesn't appear on your forehead or anything, this guy has a warrant. They gotta get in the computer and look to see, does this guy have a warrant? Somebody checked and they found out you had a warrant.
No,
So, how do you want to proceed? How do you want to change your plea now after all these years?
I mean, I'm guilty for not showing, and yeah, I don't know how it slipped through the cracks. I'm guilty. I mean,
Why don't we do this? The prosecutor will have to dig through their boxes to get your file out, but I'm sure they've got it, and it's going to have, you had taken a urine screen, so we're going to have the results of that by now. So let's do that. You want to see what the urine screen results are?
Absolutely, yes, sir.
Okay, so have a seat. Get the prosecutor to dig your file out, get the results, and we'll see what it shows. And
Okay.
we'll recall you.
Okay, thank you, sir.
So I need somebody from the prosecutor's office to come in the courtroom. I need a prosecutor's office employee in the courtroom.
deal with his vote.
Well, I didn't have, there was other people than him.
Yeah.
How about Jasmine or Missy or somebody? It doesn't have to be Mr. Hill. It needs somebody that works in the prosecutor's office.
Yes, Judge, I think he's in the restroom.
I don't, Shannon Boggs, Shannon D. Boggs, write this down. Missy, write this down.
Oh, right this side. I'm sorry, I thought you were
I want you to do
calling
some- I want you to do some
I
research.
apologize.
Shannon D. Boggs,
Yes, sir.
case number 19, TRC 4045. He's been out and about on the loose for years. He's come back into the fold like the prodigal son, although by virtue of Mr. Souers posting a bond for him. We need his file and we
Okay.
need the urine results.
Okay.
And we'll recall, so
Okay.
we'll have to move some boxes around to find it.
Yes,
So when
Judge.
you get it, let us know. Thank you.
Okay.
State of Ohio versus Joshua M. Hay, case number CRB 21-324.
And Mr. Boggs, are you staff? You're not staff here, are you? Move out of that seat. Get up here. Joshua Bay, you missed a hearing on April the 15th.
Yes, sir.
Do you admit or deny that?
Yeah, I admit it.
Okay. Got an explanation?
I got sick.
Okay, I want you to go do your urine screen and then come back.
Okay.
And we'll finish it up after you do your urine screen.
State of Ohio versus Joseph Sampson Cunningham, case number CRB 14-489.
You're Joseph Cunningham?
Yes, sir.
Cunningham, wow, you've been out of pocket for a long time. May the 12th of 2018.
10 minutes.
So last you missed a hearing then for a review on a theft offense. Looks like that finally caught up with you on April the 19th. You got arrested, had to post a bond.
Yes, sir. My lady had a car wreck, and that's how I found out that
And this is $1,500 too. So what's going on? We raised the bonds to $2,500 and they're posting $1,500. So I don't know if,
Maybe.
well, she should have known. It's been that way for a while. Okay, so, you got arrested over the weekend, right?
Yes, sir.
And had to post bond. Looking at your file, doesn't look like you ever did anything on your case. Is that right?
I'm not sure exactly. I was sent to the STAR program, and I thought everything was dismissed afterwards.
So you want to enter a not guilty plea to this?
I guess, yes, sir.
Okay, I'll accept your not guilty plea, and I'm going to require you to post additional bond, another $1,000 in bond. You're commanded into the hands of the sheriff until the bond's posted. Do you want to be considered for a court-appointed lawyer?
Yes, sir.
Do you have a job?
Yes.
What do you do?
Working with a plumber down in Huntington.
Are you paid by the hour?
No, weekly.
How much
Yes,
per
sir.
week?
I just started like 2 days ago, to be honest with you.
How much per week?
Not really sure. He's paying me $14 an hour.
$42 an hour?
No, 14.
Oh, 14. I thought you said 42. I was like, well, that's a pretty good job. Okay, I'll appoint Mr. Steyer to represent you. He can talk to you back in the holding cell.
Okay.
He'll need to post, the bond should have been $2,500, so he's got another $1,000 to post.
Your Honor, is that, Joseph Cunningham?
I'm sorry,
Was that Joseph Cunningham?
that's Joseph Cunningham,
Okay,
yes.
it says here Roger Smith was appointed.
Well, that was before, he's already pled guilty.
Okay, so we're not putting.
So we got a new, this is a new deal, so Mr. Steyer is going to represent him now. Here's his file.
State State of Ohio recalls Anthony Spencer Jr., case number CRB 22137.
Okay, it's acceptable. Not perfect, but acceptable. So your case is completed.
Okay.
Before you go.
And can I ask one more question?
Yes,
So
sir.
as far as like expungement, how does that go? How does that work?
Well, you probably need to consult an attorney or do your own research. There's a statutes in Ohio as to what the requirements are for filing for expungement.
Okay.
There is a provision where you can get this expunged after your probation is finished for a certain period of time if you don't have any other offenses.
Yeah, so because it's been so I should be good now, right? Oh, okay. All right.
I'm not your lawyer, so I'm not gonna say.
Okay.
I would say it's worth looking into. If I were you, look into it and it's possible.
All right, thank you.
You're welcome.
So do I, because I haven't, so I paid our fines and they said I owe $50 more.
I'll withdraw the bench warrant fee.
All right, thank you.
You're welcome.
State of Ohio versus John Scott Pfeiffer, case number CRB 24216. John Scott Pfeiffer.
All right, John Scott Pfeiffer has been called for 24216 case number. He actually was OR'd from the jail and given a notice to appear today at 9 a.m. this afternoon. He hasn't appeared, so it'll be a bench warrant for failure to appear.
State of Ohio versus Rebecca McComas, case number CRB 24217.
Are you Rebecca McComas?
Ms. McComas, you've got a failure to confine a dog charge. It's alleged to have happened in Rome Township, April 17th, 2024, that you allowed the dog to run free without being confined. That's a minor misdemeanor. Maximum penalty is $150 fine. Do you understand the charge?
Yes, sir.
How
Yes,
you
Your
wish to
Honor.
plead to it?
Well,
Guilty, not guilty, or no contest?
no contest.
No contest means you don't want to fight it, you're not admitting it's true, but you agree you can be found guilty without a trial and a lawyer if I think the state's evidence is enough for a conviction.
Yeah, I understand. I just want to pay the fine and go to work.
Well, I have to know what plea you wish to enter.
Oh, okay. Guilty, I guess.
Guilty means you're admitting it's true.
Well, it's not really true, so not guilty.
Okay, not guilty, then I'm just going to set it for a trial.
Well, I don't want to do that.
Well,
Yeah, what was the fine? I'm so confused.
the maximum is $150 fine. That's the most you can receive.
That's,
I'm sorry?
that would be fine.
Okay, well,
If that means I get it over with today.
to do that, you've got to basically, this isn't just
Well,
about
the
your
dog
convenience.
was in the
Ma'am,
yard.
Ma'am, let me explain things to you.
I'm sorry.
This is a court of law,
Okay,
so we do certain things a certain way.
all
It's
right.
not just for your convenience.
Okay.
That's not what I'm about.
I've just never.
Be quiet. So if you want to get this over, you have to enter a guilty plea, because you've already told me you don't think you're...
Okay,
You said
guilty.
something about not being guilty, so I'm going to either set it for a trial, or if you enter a guilty plea, that is a complete legal admission that the charges are true.
Okay, guilty.
And you understand it's an admission that the charges are true. Yes?
Yes, sir.
Okay, the affidavit says, from the officer, Deputy Frame, I was dispatched to an address for an animal complaint. When I arrived, I was greeted by a woman who was identified as Angela Evans. Miss Evans advised she was walking her dog down Cranford when a dog that was located at another address rushed from the yard, unleashed, and attacked her dog. Mrs. Evans advised it looked like at the moment the other dog was released, her dog from grip. She also advised that her dog had 2 puncture wounds. And she was taking her dog to the vet. So here, already, I got a lot more to read. But we're coming back with a guilty plea because I got to hear if she has vet bills.
Yeah, I
So
understand
I know you want to get it over with, but the guilty plea is not going to get it over with because you're going to have to come back for a hearing. Because our Supreme Court tells me if I order restitution, I've got to do it at the sentencing hearing.
Okay.
And I can't sentence you until I hear whether she has vet bills.
Okay.
So do you still want to go with a guilty plea or do you want to enter a not guilty plea?
What happens if I enter a not guilty plea? I'm
I'll
so
set it for a
confused.
trial, and then you still have to come back, because then we're gonna have a trial on whether you're guilty of letting your dog run loose.
Okay, then I'll just keep it at guilty and pay everything.
Okay, so I'm gonna let the prosecutor get a hold of Mrs. Evans, whose dog she says she was taking to the vet,
Okay.
because I can order you to pay the vet bills, but I can't order them until I know what they are.
Okay, that's fine.
So, let's go out. Are you employed, Mr.
Yes,
Thomas?
sir. Yes, sir.
I'm going to have to set this on a Monday or a Friday. What's better for you? Mondays or Fridays?
Friday would probably be better.
Okay, May the 10th. I'm going to set it as your sentencing hearing. So
That's fine.
I'll accept your guilty plea. I'm delaying sentencing so the state can bring in the complaining party to see if she has restitution. It'll be May the 10th at 10 o'clock for sentencing, 10 a.m. I'm going to let you sign a signature bond of $500. So what that means is you're signing a piece of paper that says, I promise to come to court, or I'll pay a $500 penalty for not showing up. So you don't have to post any money.
Okay.
Just come to court, May the 10th. And if you have evidence you want me to consider, have that with you. If you got a witness or somebody you want me to hear from, May the 10th, I need to hear from.
Okay, sir.
Do you have any questions?
No.
Okay, May the 10th, 10 o'clock is your next hearing. Okay, that's all. You're free to go.
All right, thank you.
You're welcome.
State of Ohio recalls Joshua Hay, case number CRB 21324.
Okay, you got a good screen, Mr. Hay. Congratulations.
Thank you, Your Honor.
Still have some more fine to pay off. Can you make a payment today?
I didn't know how to payment today, Your Honor. I've been having a hard time. My home got destroyed and stuff during that storm, so.
You can work, you owe a little less than $200. If you work April 27th, you get a $100 credit toward your fine. If you work May 4th, you get a $100 credit for your fine. Those are double credit. Any other day, you get $50 credit. So I'll set it for another hearing. May 24th is your next review hearing. When you get this paid off, you won't have to come back for these hearings.
Okay, thank you, Your Honor.
You're welcome.
State of Ohio versus Philip Hill, number CRB 24218.
You're Philip Hill?
Yes, Your Honor.
Bail's bringing you a copy of the charge. It's, the charge is violation of a protection order. It alleges that in Union Township on April the 20th of this year, you violated a protection order that was issued or a consent agreement. That's a first degree misdemeanor, maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you plead?
Not guilty.
Do you wish a lawyer appointed to represent you?
Got an appointment with one right after this, sir.
Okay. So I'm going to set it for May the 10th. That should give you enough time to engage a lawyer.
Okay, well, just so you know, I had set an initial consultation for the divorce. He didn't schedule that till May 20th, but she keeps, enacting and doing things. So he agreed to see me so he could file, some motions to see the children, et cetera. So
Who's your lawyer going to be?
Brigham Anderson.
Okay, well, he can't represent you in this.
Okay.
That might have to be a special prosecutor. He's the prosecuting attorney, so he can't prosecute you and defend you at the same time. So,
Okay.
what's the office's? I think that is the position. If he's representing someone in a civil matter, then the office is conflicted out, or?
Normally, we would do it that way, and I guess, and I don't know if they've had a consultation already, and if it starts then, or it starts when he's retained, but we certainly want to make sure we do it the right way, whatever it is.
Okay, well, here's what I'm going to do. I'm going to go ahead and set it for May the 10th, and then I'll decide if we need a special prosecutor.
Okay.
If Mr. Anderson is conflicted from being the prosecutor, then he can't defend you and he can't prosecute either. He can't do either one, so you need to get another lawyer, and I'll have to appoint someone else to be the prosecutor. Well, I'll decide that on May the 10th. That'll be your next meeting. In the meantime, apparently at least there's an allegation, there's an order for you to stay away from a certain person. Julia?
Yes, sir.
I assume. So I think you're aware of that?
Yeah, now, and again, just to make you aware, sir, we went on the 18th to do the hearing for that. When he awarded her the residency of the house, I wasn't concerned about where I was staying, but I did let him know that I work from home. I have to have an inline, no Wi-Fi. I have to have an inline to work, which I said, I wasn't really sure where I could go to accommodate that. I said, I'll check with my father, but he lives across the street, because my father owns that house, the house that I'm staying in. My brother is next door to me. So, I could sleep on his couch, but he couldn't accommodate like any of my stuff or my workstation, and he's got grandkids running around everywhere, so it's not really conducive to let me work there. So he asked me to check with my brother to say if I could stay in his rec room that's right beside his house. They're about the same distance from where I'm staying. And I asked him if that was going to be a problem. He said, well, if that's what you have to do, he said, I won't enforce the 500 feet.
So it's your father that has the protection order?
No, it's me. My father lives across the street. That's where I told the judge that
Oh, the judge, you're talking about, you said
Yes, sir.
you're talking about the judge.
Yes, sir. He said the judge wouldn't enforce the 500 feet, essentially just stay away from each other, be adults. I agreed. She never saw me, heard me. She just knew I was staying over there instead of across the street. And she had called, to have me arrested. Immediately after which, I hadn't even made it to the jail, and she broke into that rec room, took the keys to the car that I had. We have two cars. I had just bought the other car that she took less than a week prior. But she broke in there, took a bunch of stuff, including the keys, loaded up totes of things into that car, and now she has both cars. She left the new one there, but locked it. I don't have a key. And again, I think she just had me arrested so she could go take what she wanted, and then leave me without a car as far as being able to get to court or otherwise.
Well, it sounds like you definitely need to talk to your lawyer.
Yes, sir.
On the
Yes,
divorce
sir.
matter. So
Yes,
anyway, you got some time to try to work it out. May the 10th will be your next hearing here. And I'll deal whether there needs to be a special prosecutor at that point.
Okay.
Sometimes these complexions of these cases change over time, so maybe by then it'll be a different complexion on the case. But at this point, that'll be first inquiry.
Understood. And is there a certain time for that? Just 9
10
o'clock?
o'clock, May the 10th.
Gotcha. Thank you, sir.
Yeah, he can sign, he's got a bond up, so his bond's continued. You've already posted a bond, I think.
Okay.
That's all.
Thank you, sir.
You're welcome.
State of Ohio recalls Joseph Sampson Cunningham, case number CRA 14489.
Mr. Cunningham's in custody.
Yes. I think what happened on response is Gary was out of town with his son, so I guess they just take whatever they tell.
Your Honor, I discussed the matter with Mr. Cunningham, and I'm gonna have, I'll need to do some further research to confirm exactly what's going on, but the misunderstanding here was that he was sentenced to STAR, possibly out of the same incident, which is what I need to do some research on. He was convicted here of a shoplifting charge, but apparently, and I didn't represent him on this, I went to dig into the case file in College Police Court. There was a drug possession that arose out of the same incident that may have been separately charged in College Police Court. So because it came out of the same incident, when he completed his case there, he thought that this was complete as well, which is obviously incorrect, but I think there might have been not a totally unreasonable thought. So I'd like to look into that and just kind of see what the history of that is. But in the meantime, I recognize that the amount of bond that was posted is not the amount that the court currently requires for this sort of a charge. However, I feel at this point, in this instance, the $1,500 that he posted was sufficient to secure his appearance here as he is here under his own steam with that bond. So I'm going to ask that that bond be left in place for the reason that having another $100 to Gary Sowers, because $100 doesn't go to the court in a case that at this point basically mostly about getting the cost paid. So under these set of circumstances, I think it would be wise for the court to allow him to remain out on the bond that he's already posted so that further funds can be put toward this. He indicates to me that within about a week he can pay at least $100 to the court. So I heard you earlier saying I'll set stuff till May the 10th, but I think in this case I'm going to say if you wanted to set this for a week from today, I would tell him to be here that day with money to pay the court. And then we can maybe at that point look at a little bit longer leash. Or if the court preferred to go out a little further because of, the question of the docket getting too heavy, I would understand that as well, obviously. But I'm saying we're not asking for a long time to get started on this. Now, I don't expect him to have $500 in a week, but he says he'd have at least $100, maybe more, in a week's time.
What's Mr. Cunningham's current address?
Go ahead, Tom.
222 St. Charles Street.
St. Charles?
It's over.
It's in Colgrove? Okay. Before you lived in Huntington? Well, even better. All right, well, I don't really care. It makes no difference to me whether he pays the fines, except that he was ordered to do that. It's my duty as a judge to enforce court orders. And with a $1,500 bond posted, Mr. Sowers would go to the end of the earth to get somebody before he would voluntarily pay $1,500 to the court, which he would have to do if you don't show up.
He certainly does Colgrove.
And going to Colgrove, for 1,500 cents, he would go to Colgrove to avoid paying that. So, I feel pretty confident you will be back in court, otherwise you'll be needing to look over your shoulder constantly and leaving the jurisdiction. All right, I'll set it for May the 10th for a pretrial and review. He can be released.
Thank you.
You're welcome. Okay, we're starting pretrials now. Anyone that's got a pretrial out in the lobby needs to come in.
State of Ohio versus Zachary R. Dement, case number CRB 23101, CRB 22553, CRB 22506, CRD 22257, A, B, and C.
This is Mr. Thompson's case, Mr. Dement's at Shawnee. He's they gave you a sweatshirt even that says county counseling soon, so that's good. Yes. And we've got a report. Okay, it's a good report. I think we've had a few little hiccups that you've addressed along the way. I get texts, and people don't believe this, but Leslie texted me at one point about some things with you, so, and that's common with, I'm constantly getting updates about the people I've got in treatment, so I'm roughly aware of what's going on.
I know you are.
And so, it looks like you're on course now to do what you need to do. How do you feel about things?
I feel great. I like the place, for real. I do. I love it.
And you look good, so what's your attitude going forward?
I'm gonna try to get a job in treatment. I'm gonna get my CDCAs. I'm gonna work on that here soon, as soon as I get off probation.
I think that's a good plan. I applaud that. Okay, good job. Keep it up. Let's come back. Do you have a projected graduation date?
I think within the next 2 weeks, he'll be moving down back into 2.5. And then from there, I think within 30 days, he'll be completed.
Okay, well, let's come back in about 30 days and see where you are then. So let's look. So maybe we need to go to June. Got that holiday in there. How about June 3rd, Mr.
That's fine, thank you.
Thompson? Next hearing will be June the 3rd. Look forward, maybe you'll be graduated by then. So keep it up. Good work.
Thank you, sir.
You're welcome.
Thank you.
State of Ohio versus Danielle Lynn Justice, case number CRB 24126, CRD 24520. Danielle Justice.
Set for pretrial.
We're awaiting discovery, but also the prosecution wanted to get Ms. Justice assessed for mental and AOD issues. So.
We have an assessment set up at 10 o'clock in the morning.
When is it set?
I'm sorry,
Tomorrow.
10 o'clock in the morning tomorrow.
Okay. May the 10th is the next, well, that's a Friday, so you don't want Friday. May 6th? Next hearing is May 6th, 10 o'clock.
Thank you.
You're welcome.
Here.
Yes, ma'am.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Lindsay T. Miller, case number CRB 23625.
Your Honor, this is set for a trial next week, so there's really nothing we need to do here today.
And Ryan, Haley Early, Project Hope will not take her back.
It's all right, you can.
You can't take her? Great. All right, now I have this as a pre-trial with a trial set next week, is that correct?
Yes, trials.
Anything we can do today on the pre-trial?
We would be willing to propose an agreement that if she pled guilty to the pending charge, that we would recommend no imposition of jail time, just a suspended jail sentence.
We're not going to plead guilty.
Okay, and I've got, looks like there's some recipe for subpoenas for witnesses that were filed some time ago, so they should be out and served by now. So it's on the docket for next Monday, the 29th at noon for trial. So that, it'll go forward then.
Okay, thank you.
You're welcome.
State of Ohio versus Timothy Atkins, case number TRC 23-1834, A and B.
This is Mr. DeWaters' case, and it's set today as a pretrial.
It is, Judge. We've, just as far as status of this case goes, we have completed discovery at this point. I talked to Mr. Adkins the other day, but haven't yet had an opportunity to get him in the office to look through everything. I talked to Mr. Hill this morning about having a final pretrial on the 20th of May. That'll give me, if that's okay with the court, that'll give me time to get with Mr. Atkins, figure out if there can be a resolution, and then if not, we'll pick a trial date at that point.
All right, May 20th will be the next hearing.
Thank
Set
you.
a trial at that date at that time is not resolved.
Judge, I've got an entry prepared in that regard. You want it? May I approach, or do
Yes.
you already have one?
State of Ohio versus Jamie L. Townsend, case number TRC 24-662, A and B.
Mr. DeWaters' case set for pretrial.
Judge, I talked to Mr. Hield about this during pretrial conference. This is a first offense OVI. While it is marked as a refusal, and it was, there was a portable breath score obtained in this case that gives us some indication of where Ms. Townsend would have been. It does not appear that it would have been an aggravated situation, but she wants to enter a guilty plea today to the charge, and it's my understanding Mr. Hield's willing to recommend the minimums as a
Is that correct, Ms. Townsend?
Yes.
All right, Mr. Hill, do you have any recommendation or statement you want to make?
Your Honor, it is a first offense. It is marked as a refusal. She did submit to the PBT, which indicated .154. We don't have a problem with the court basing the fine on that if it's maybe less than a refusal would be.
Yes. Ms. Townsend, you have a right to make a statement to the court if you wish to do so, but you're not required to. Do you wish to say anything? No? All right, I'll impose a $600 fine. Order you to pay court costs. So that saved you $400, because normally if you refuse to take tests, I impose a $1,000 fine for refusal. So since you kind of backed off of your refusal, I'll give you a break on your fine. So $600 fine, 6-month license suspension, and that starts the date of the offense, April 1st. You can have, I'm assuming she wants limited driving privileges, or?
She does, Judge, for purposes related to work or court, or if you impose any community service, that too.
Okay, so she can have limited driving privileges for community service, court, employment. She'll get that from the probation office here. And to go to the 3-day school. The driver intervention program, you have to do that, or I have to give you jail time, so I'm going to give you a suspended jail sentence. On the speeding offense, I'll impose a $75 fine. Uh, 20 days in jail, all suspended. You have to do 5 days of community service. We have a community service program here. You can work any day but Sunday. And now we even have community service on Sundays. If you want to work Sundays, you can do it at the dog pound, but you have to make an appointment to do it. You just can't show up at the dog pound. You have to pre-arrange to do it on Sundays. But 7:30 any day of the week other than a holiday, Monday through Saturday, you can work here. And there's 2 days coming up where you can get double credit. April 27th, May 4th. If you do those days, you'll have 4 days by doing those 2 days. Our review hearing is going to be October 21st. October 21st at 9 a.m. She used to meet with Mr. Major, who's out doing double duty as security and probation. This court, our motto is we do more for less. It's pretty good.
I'll have her meet with Mr. Major here just as soon as he's available, Judge.
And any questions? That's all.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Robert Woodard, case number CRB 24-127.
It's Mr. DeWater's case, pre-trial.
Judge, I talked to Mr. Hill about this case during pretrial. May we approach?
Yes. Okay, it's my understanding from bench counsel with attorneys that there's an agreement to continue this for 90 days, and in the intervening time, Mr. Woodard's going to get an assessment.
That's correct, Your Honor.
There's a time limit.
Yes, sir.
Last week of July 22nd, 26th, 29th, somewhere in there.
Yeah, 22nd. Be fine.
Seeing as he's going to be assessed, I think it might be appropriate to see what the assessment is before we go out all that way.
Okay, we can come back sooner.
Okay, how about, let's see, June 3rd?
Okay, June 3rd. Does he know where he's gonna go?
No, he does not, Your Honor. This came up this morning, so what I plan to do is have him talk to somebody here before we leave today.
Okay. June 3rd for pretrial. 10 o'clock.
State of Ohio versus James G. Adams, case number CRB 24130. James G. Adams.
James Adams. This is your case, Mr. Doyle?
Yes, it is, Your Honor. We may have this one resolved. We've been working on it this morning, but we're waiting on a return phone call before we'll know for sure.
Recall it later in the docket?
Yes, if that's okay.
All right, will you recall?
We're headed to the Lawrence County Jail.
Okay, we're going back to the jail.
State of Ohio versus Haley Early, case number CRB 2480, and Bridget Ellis is on deck.
Okay, I've got Haley Early about the teleconference at the jail. Miss Early, can you hear me? Okay, so I did some work on this, and I'm multitasking while I'm on the bench. Project Hope said no, they would not take you back. I told you when you were here before, they're really strict, and they've got their choice. I mean, they've got people lined up trying to get in that facility. So as soon as you left, there was 10 other girls that wanted to get in there, and they took one of them, so your place is gone. But I've got a good alternative for you. The counseling center has a similar program where you can eventually get your kids to come with you if you mind your P's and Q's and do what you're supposed to. Called Stepping Stones, I believe is the name of the facility. That's correct. Program. And they're willing to take you today.
Okay.
Are you willing to go?
Yes.
Okay. And you're going to stay?
Yes.
Because you know I've got 6 months hanging over your head, and I will give it to you if you don't. I'm going to give it to you for the benefit of your kids and your grandma. And your mom. I don't want you to do another day in jail. I really don't. And I hope you never do another day in jail. But I will give you all the jail I can if it will get you to treatment and get you clean. This is really important. Do you agree?
Yes.
And you may not get your, well, I'll just go out on the limb and say you're not going to get your way with everything that you want at the counseling center. You know, they're going to have rules too, just like Project Hope. I don't know, they may have rules about phones, and I'm going to go out on a limb and say you're not allowed to have a vape there. Is that correct?
She can vape.
You can vape. Okay? But you got to follow whatever the rules are. And like, I've had people before like, I'm not getting up and cleaning my room. I want to sleep till 10. Or, you don't get to make the rules. You got to follow the rules they set.
Right.
Okay? And you're going to do that.
Yes, and I remember to see my kids like molesting them, like instantly there, or
I don't know about that. It's probably not instantly, but
It's not instantly.
But eventually you will. You didn't instantly get to see him at Project Hope, did you?
yeah, I did.
Okay. Well, they weren't living with you at the time?
Not right off.
Okay, that's what I thought. But eventually they were going to get to come live with you.
Mm-hmm.
Same thing here. Eventually you do what you're supposed to do. Your kids are going to get to come there and stay too.
Okay.
That's a huge deal because there's not very many facilities that will allow that.
All right.
So, okay, so I'm going to order you released to the counseling center today to go to Stepping Stones, and then I want to see you back.
Is my grandma able to take me files up, so we can get my stuff.
Well, I don't know about that.
I'm here.
She's here in court.
Okay, I seen her.
Yeah, she's the one I got on this. I didn't realize at the time that was your grandmother that I got on about talking while I was giving instructions. Is it Dorothy? Is that your name?
Debbie.
Debbie, okay. I've talked to her before on the phone, haven't I?
Yes,
And you're on board with all this?
yes.
Are you okay with coming to get me and taking me to get my stuff and then taking me there?
No, she's not taking you.
Okay.
I can't get her stuff.
She can get your stuff and take it, you can take it to Portsmouth?
No, we live in Huntington.
Well, I know that, but she's going to Portsmouth.
Oh,
That's where the facility is. Or you can bring it here to the court, there's somebody, he's here every time the door's open, he can get it here and take it to her.
okay.
Or you can bring it, he's gonna be here for a while. Okay, Haley, you're not making the rules anymore.
Okay.
I know you've made them for 23 years.
No.
That's part of the problem. Part of the problem, okay, just be quiet, listen, I'm in charge. You don't get to make the rules.
Right.
Say, okay, Debbie, go get her stuff. You just live like 2 miles from here, right?
Yep. just
Fourth
go.
Avenue. Go get her stuff, bring it here, give it to Ryan, he'll take it to her at the counseling center. So no excuses. What other excuse have we got to not want to do what you're supposed to? Anything else that I can fix? No?
Just make sure you get all, she can get all my stuff, like even from the front desk, but that's fine.
Okay, I don't know what all your stuff is, but there may be some stuff you're not allowed to take in.
Right.
Figure it out.
Okay, they'll figure it out, so, but this is gonna be a process, and, I mean, the last time you were at OVP, I could just tell a difference in you after a few days.
Right.
So, and I got a report that you were wasted over the weekend.
I did have a drink, but
Okay, I won't give you away, but I saw the signal. Okay, this is the beginning of a new life. Make it work. You've got great opportunity here. And for these kids,
all right, how about they can bring them to me up there? We'll figure it
they
out.
will. They will eventually, but it's not going to be on your schedule. They've got rules, they're going to tell you what the rules are, and you're going to follow them. But eventually, you do what you're supposed to, your kids are going to come stay with you. Okay, I think I need to see her. I just want to report on her. I don't have to actually see her, or you can put her on teleconference or whatever, next week, April 29th. I want to report on her then, so I'm going to put her back on the docket.
I have court the 29th in Powell County also.
Okay. All over the kids
Yeah,
with children's services?
yeah.
Okay. Well, and I'm sure they already know that you left Project Hope. Right?
Yeah, because I was supposed to see on Wednesday.
What?
Yeah, because I was supposed to see on Wednesday to, like, call, check in with her, because she had been left. Because I was supposed to have a visit every Wednesday.
Well, is there someone here you want contacted from Children's Services? Do you have a caseworker?
Yeah,
What's her name?
Sydney Mullins.
Sydney Mullins?
Yeah,
We'll do that once she comes in, Your Honor.
yeah.
It's part of the process.
Okay. All right. Ryan says they will get in touch with Sydney and let her know what's going on. And I would think they're going to be on board with you doing this. I can't imagine they won't be. They were on board with you being at Project Hope, weren't they?
All right.
Okay, I'll see you next week with a good report. And you're not going to leave between now and then, right?
All right.
Okay, see you. I'll set it as a pretrial for April 29th at 10 o'clock. You don't have to actually bring her unless you want to. If she needs tuned up, you can bring her. I'll tune her up. If she's doing well, just give me a report, or put her on teleconference.
Okay.
Okay, good luck, take advantage of this, no more mistakes, you've had your mistakes. You're welcome.
State of Ohio versus Bridget A. Ellis, case number CRB 19820, CRB 18235, CRA 18171, CRB 16133, and Belinda Fuller is on deck.
All right, Bridget Ellis is here on a warrant. You were doing so good, Bridget.
I know.
It's alleged that you missed a review hearing on January the 16th and got a warrant issued because of it. And
Yeah, I did community service, I did 2 days of community service, I just didn't get a training.
Well, do you admit you missed your hearing on January the 16th?
Yes, I did.
Did you relapse?
Yes,
We need to get you back in treatment?
yes.
Where were you before? At Bethesda?
Hope source.
Hope Source. Bethesda, Kentucky. You willing to go to Bethesda?
Now I want to go back to Hope source.
Well, that didn't work out so well last time.
I mean, I'm willing to try again, yeah.
Your Honor, if I may, Ms. Ellis has the warrant out of Proctorville also.
Okay. You got a warrant out of Village of Proctorville too.
Yes.
So I would suggest if you will agree to go to Bethesda, I'll do what I can do to twist the arms of people in Proctorville to let you go.
Okay.
You're okay with that? You want to talk to her first, Taylor?
Yeah, okay.
I mean, I can assess her from here.
Yeah, I'm good.
Okay, let's try to get a hold of the Village of Proctorville, see if they'll agree to release their warrant so you can go to inpatient.
Okay.
I'm assuming you don't have any money to give them anyway.
No, I don't.
That's pretty much what they're interested in.
Right.
So we'll call you back after we get word from them. Maybe you need to call the mayor or somebody. I'll have you back after we talk with them, see if we can't get them to release their warrant.
Okay, thank you.
You're welcome.
State of Ohio versus Belinda Fuller, case number CRB 21753, Elizabeth Hunt is on deck.
You all okay, bro? Yes, this is Mr. Stratton's case. Belinda, do you have a medical card?
Yes, sir, I do get a medical card. I'd like to say I'm sorry for being the smart-aleck person I was, but I assume you were Friday.
Well, I understand. You were under the influence then.
No, I wasn't under the influence.
Yeah, you were.
I mean, sir.
Yeah, you were. You were under the influence. But now you're not, so you're much better.
I still shouldn't have been medical to you, and I'm sorry for being that way.
You're a totally different person today.
Thank you.
What's your, do you got a West Virginia or Ohio medical card?
I have an Ohio medical card, sir.
Okay, you still have it?
I still have what, sir?
You still have an Ohio medical card?
Yes, sir, I have an Ohio medical card and food stamps, sir.
Hometown? Okay, I've got a bed for you, inpatient at Hometown Recovery. You willing to go? You need to go.
Yeah, I want to do outpatient, but I'll do recovery.
So I know you need inpatient. You did inpatient before. Here's the thing, one that we know before, I'll tell you, maybe I shouldn't say this to you, but I'm going to. You surprised me the last time you went to inpatient, how well you did. You did really well for quite a period of time. And then when you went off the rails, you went way off. Didn't you?
Well, I found out my man was cheating on me again. I think they was part of it, no count.
Okay. Well, you got to do this for yourself.
Yes. She's willing to go, Your Honor.
Okay, so I'm
I'm
glad.
willing to go, I was just hoping to do outpatient.
Well, I understand, but you need inpatient.
Yeah.
Okay.
I'm going to release you, and this solves your housing problem, everything. You have a place to live, food to eat, and that, I understand you've been homeless for a while.
No, I've lived with my boyfriend for 6 years.
Okay.
I've not been homeless.
All right, I'll order you released to Hometown Recovery today. And come back in 2 weeks,
Yes, Your Honor.
May the 6th.
May 6th.
You're here then?
And how long am I supposed to do there?
Till you get clean, till they say you're finished. Kind of reminds me, Abraham Lincoln was asked, because you know he was very tall for the time, how long should a man's legs be? Long enough to reach the ground. So, it's like, how long should your treatment be? Till you get in recovery, till you're clean. So whatever that is.
I go to smoke crack every day, I do it 3 times a month, period.
3 times a month. Well, I don't think smoking crack at all is good, so. See you in 2 weeks, May the 6th.
Thank you.
What's the name of the place again? I'm sorry.
Hometown Recovery.
State of Ohio versus Elizabeth Monk, case number TRD 2167A and B. We'll be recalling Bridget Ellis next.
Elizabeth Monk. You're Elizabeth Monk?
Yes.
All right, Ms. Monk, I think you know I'm Judge Capper. It's alleged you didn't come to court for a review hearing back in October of 23, October 23rd, 23, and you didn't do anything on your case.
I forgot the time I was in the hospital and I have 2 kids. I'm a single mom. I forgot to go to court, I forgot to pay my fines, and they took me up from work, and here I am to go back on.
Well, forgetting to go to court is a bad thing. I don't know how that happens. I don't know how somebody forgets to go to court, but I guess people tell me all the time, I forgot to go to
My
court.
mom was, her liver enzyme was 500,000, and I was in the hospital with her. And like I said, I'm a single mom, I got a 5-year-old and a 2-year-old, so it just slipped, and I'm absolutely sorry.
How long you been in jail now?
Just overnight.
Okay. It's not a good experience, is it?
No, I do not like it at all. My kids are at home, and it's just not a place for me.
I don't want you to go to jail.
Right?
I just want you to do what you're ordered to do, but I don't have, I tell people this all the time. Back a few hundred years ago, they had the public stock, so they'd have something out, I don't know if you know what that is, in front of the courthouse, where you stick your hands and your head through and they lock it down and make you stand there all day. That'd be a lot cheaper.
Yeah.
But they did away with that. They said that was cruel and unusual. So now all I've got is jail, fines, community service. If you won't do the fines and community service, what am I supposed to do? Say, okay, Elizabeth, that's okay. I know you don't really want to do it, so don't worry about it. You got kids, you got a mom that's sick. No, that's what you are saying. That is what you're saying. Okay, just be quiet for a minute. Be quiet. You either gotta do it or I gotta put you in jail.
Right.
That's the way it works. So I would be, that's how I don't understand why you forget about it. So I'm gonna tell you something, you should know it now. If you don't come to court, you're gonna get a warrant and then you're gonna go to jail. That would scare the heck out of me.
For sure.
Because I visited that jail. I would pay a lot of money not to spend the night in that jail.
Right.
If I had to crawl to court, I would do it to avoid spending the night in that jail.
Right, sir, and I'm sorry that I was not there and I didn't do what you asked me to do.
Okay. I even told you lived in Portsmouth, don't you, or Southern County?
I was in stepping stones when I seen you last, I completed stepping stones.
Great.
I got my house, I got my kids back, I got things for the same.
Okay, well, that's all great. I applaud that. I just put something, this morning, I've sent another girl that's in the jail there with you, she's going to stepping stones.
I was just explaining to her it's a really good place and I really recommend it.
Okay, good. Hopefully she will listen to you because she already got kicked out of one place. Or actually, she left on her own. She
Yeah,
didn't.
stepping stones is really like, they work with you, they try to find the problem.
Okay. Well, I'm glad you did well there, and I want to encourage you, and I don't want to put you in jail, but if you don't do what you're supposed to, that's my only option.
Right, I understand.
Okay, so I'm going to release you today. So it's like a little slap on the hand. You get 1 day, slap on the hand, now you know what's going to happen, so no excuses. And I'll give you another date when you got to come back. And I'm going to give you time to get this finished.
Okay, so just pay my fine, right?
You've got $290. I didn't even give, well, it doesn't even say there's community service on this.
Right, I didn't think I had community service, I thought it was just, I had to pay it.
Well, I think what I wrote, because I think you said you didn't think you could pay, and I said you could do community service to pay off.
Yes, I remember now.
I even told you you could do it in Portsmouth. You can go to the Portsmouth Municipal Court, do your community service there, and I'll give you
I
50.
can do community service at Portsmouth Municipal Court?
You can.
Okay, I did not know that, I was in stepping stones at the time, I remember.
That's probably right across the street. It's close, isn't it?
No, it's down the road, I know where it's at.
Okay. It's right there on the, is it still in the old building?
Yep,
Yes, the old building. I mean, this-
Right on the river, close to the river.
for the time being.
So, if you can get up here on April 27th and May 3rd, those 2 Saturdays, you get $100 a day credit. But you gotta get here at 7:30.
April 27th and what?
The last Saturday of April and the first Saturday of May.
Write that down, last Saturday.
May 4th. May 4th, April 27th. Double credit.
And I'm sure I could get up here.
I'll set June 3rd.
All right.
June the 3rd, the first Monday in June, is your next hearing. I canceled the warrant. You're going to get out of jail today. Unless you got another warrant from someplace else I don't know about.
No, I do not, sir.
Okay, take care of this.
You too, thank you so much.
And stay clean.
I will.
Okay, good luck.
You too.
State of Ohio recalls Bridget N. Ellis at the Lawrence County Jail, case number CRB 19820 and others.
Your Honor, if I may, I talked to him at the property bill, I talked to Mr. Bates, and he said that he was, did not want to do it, but he said he would send the release to the jail.
Okay. All right, so I went out and I've got to drive through Proctorville all the time. 2 or 3 times a day. So you know what they mean? They're going to check my license certificate, the little sticker on the back, every time I would drive through there to see if it's valid now. Well, I think they do that anyway. But, so they're releasing the warrant. They didn't want to, but they're going to let you go to treatment. So take advantage of it.
Okay.
And she's going to go to Bethesda.
All right, thank you.
And you know what to do because you've been clean before. You know how to do it. And you've done it for fairly long periods of time.
Yes.
Okay, you got to get back there and make it work and stick. So I'll see you May the 6th, 2 weeks.
Thank you.
Okay. Set it for review on May the 6th. Okay, you'll get picked up today.
State of Ohio versus Agnes Sexton, case number CRA 24209, CRB 24210. Timothy Summers is on deck.
Let's get the officer. Your Honor, we have the officer here. I want to have him in the courtroom too.
Okay. Mr. Smith's case, Tyler Smith, is set for a pretrial today. She looks much calmer than she did Friday, too.
Your Honor, I talked to her this morning. She seems in a better place.
Yeah.
Approach, Your Honor.
Yes. She's left. All right, Ms. Sexton, talk to your lawyers, and they've agreed. You have a felony and a misdemeanor that's new, and you've got some old misdemeanors still hanging around. So what's been worked out, and this is really a good deal for you, if you will do it and take advantage of it. I'm going to release you to go to Mended Reeds for treatment, and that's going to happen today. They already said they got a date for it.
I believe so, Your Honor.
Your case is going to stay here. You've got a felony. But rather than take the felony to the grand jury and get you indicted and have you go to the common police court, where the common police court can send you to prison if they want to on the felony, you're going to stay here in this court. If you do well, eventually the states are going to dismiss the felony. You don't get an indictment. You don't have a risk of going to prison. And your case stays here in the misdemeanor court. But you got to do the treatment, you got to get good reports and do what you're supposed to do. Your lawyer tells me you're on board for that. Is that correct?
Yeah.
Okay. And I think that's a wise decision on your part. It's a good plan. Mr. Hill.
Just want to clarify that we're not suggesting that the assault charge would go all the way away, but we could make it a misdemeanor, and we would give her a lot of credit for going through counseling and not ask for more jail time.
It's the felony only, as I understood it was going to, the assault on police officers, that's the most serious charge. They're willing to drop it, but she would, oh, okay, you might amend it to a lesser misdemeanor.
We would still expect a plea on it if she does really well in her counseling. Now, then if she doesn't want to do that, then we'll still have the option of taking it forward to the felony.
Yes. And if you, I'm not going to put a monitor on you. That was considered at one time, putting a GPS monitor on you. But I'm not going to do that yet. If you leave, though, the option the state has, they can just take it to the grand jury, get you indicted on the felony that's pending. There's nowhere you can go. I mean, a felony warrant's good in every state and most countries in the world. So you can't escape this. You got to face it. And the best option is go to treatment, get clean, and get the felony dropped down to at least a misdemeanor.
Yes, sir.
Okay, and you agree with all that?
Yes.
Okay, I'm putting on an order today that you be released to Mended Reeds for treatment. And then what's gonna happen is you'll come back here, and I think you know this from prior occasions, you're gonna come back here and I'm gonna get reports from Mended Reeds how you're doing.
Okay.
And if you gotta do what they tell you to do, unless it's illegal or immoral, you gotta do what they tell you to do, when they tell you to do it, how they tell you to do it. You understand?
Yes, sir.
And you're agreeable to that?
Yes, sir.
Your Honor, the bond was set at 10,000 cash or surety on Friday, so I'll
I'll
assume.
drop it to 10,000 OR. So I'm giving you a signature bond on the conditions you go to Mended Reeds. And we'll see you in 2 weeks on May the 6th for a report. You're available.
Can I make one statement to opposition? I appreciate how kind you was with my son. I'm sorry what happened. That is the truth. Me biting you, but, you had just a real good, like, bedside manner with it. I was watching you, and I appreciate that. So, thank you.
You're welcome for saying that. Okay.
I am available at 6, Your Honor.
All right, May the 6th is going to be the next hearing on all the cases she has.
State of Ohio versus Timothy Summers, case number CRB 23749. Michael Davis III is on deck.
Sir, are you Timothy Summers?
Yes, sir.
Mr. Summers, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. You are appearing in the courtroom today on a monitor. Everything's being recorded, what you say, your image is being recorded. So if you admit something about your case, the prosecutor sitting right here listening to it, he can use it against you. You don't have to say anything. You have a right to remain silent. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail. You have a right to make the state prove charges beyond a reasonable doubt. Do you understand those things?
Yes, Your Honor, I do.
You're charged with telecommunication harassment. This is an older charge. It's alleged that this happened on December the 6th of 2023 in Fayette Township, that you made or allowed to be made a telecommunication from a device under your control with the purpose to abuse, threaten, or harass another person. That's telecommunication harassment. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
I don't even go to Fayette County. I'm not familiar with this charge at all, Your Honor.
It's Fayette Township, not Fayette County. It's in Lawrence County.
I'm not even from here, so I don't even know how this charge is. I have no idea how this charge is being. I've never heard this charge in my life. I'm in here for, I was supposed to be going to TCC today, and there's another court date, was that court on Friday, they said it was court on Monday.
Well, just look at the affidavit, and the allegation is you sent a text to somebody in Lawrence County at Fayette Township that was threatening. So that's the basis of the charge. It may not be true. You don't have to admit it's true. You just need to understand it. Do you understand that's what's being alleged?
Yes, sir.
Do you have the money to hire a lawyer?
No, I have an attorney for my other charges, Rick Nash, so I'll have to speak with him one day. I was just hopefully I can get a lawyer on.
Do you have other charges in this court?
Your Honor, if I may, he was here Friday, he got released with ankle monitor, and there was not an ankle monitor available.
Okay.
The prosecutor's office found out they had new charges, so I told them to put him on.
Okay. So you've got some additional charges. What's the state's position on bond now that we've got this added in the mix?
We want him to go ahead on to treatment, and the ankle monitor can serve in this case also.
Okay. So we had agreed for him to go to the counseling center, I believe. So that's still the plan. You're still willing to go there?
Yes, sir.
Okay. I'll just add to this a $2,000 signature bond with a protection order. It's requested, I assume.
Yes, Your Honor, we'll have to draw one up.
Case number is 23749. And that would be Bethany Camlin is the protection. So you're not to go around, contact, text Bethany Camlin.
Yes, Your Honor.
And I'm still going to let you be released to the counseling center with an ankle monitor. So the problem Friday is we couldn't get one.
They're still not available, I don't believe.
Okay, and there's still not any available. Ankle monitors are very popular right now. You got a lot of people out with. So I'll allow you to be released when one's available. And who is your, Mr. Nash is your attorney?
Yes.
Okay, I'll put him down on this case. When did we set the other one for a hearing? It's Soumemmers. Timothy. Okay, set for this Friday. Or that was last Friday.
Let's see. It was waiting for the grand jury.
Oh, it's already been waived for grand jury.
Yes, on the 15th.
You want to acknowledge this to the grand jury then?
It wouldn't fit with that other charge.
Okay, it's a different date.
Yeah.
Okay, let's put it on for May the 6th.
And I can send Mr. Nash a message asking if he's going to be representing Mr. Summers on this case.
Okay. All right, your next hearing, Mr. Summers, is May the 6th. Hopefully you'll be on your way to the counseling center. Way before
You
then.
got my phone way to the ankle monitor, Your Honor?
I do not. Do you have any idea?
No, they told me Friday we was back.
Okay, I do not know.
You do not know. Okay, thank you.
Okay, sorry.
We did have one for on Friday.
State of Ohio versus Michael Davis III, case number CRV 24215.
Sir, you're Michael Davis.
Yes, sir.
Mr. Davis, it's alleged that Fayette Township on April 22nd, 2024, you knowingly caused or tried to cause physical harm to Lindsay McMillan, that she's either a member of your household or a member of your family. So that's a domestic violence charge. It's a first-degree misdemeanor, maximum penalty, 6 months in jail, $1,000 fine. You're going to be representing Mr.
Well, I don't know if I'm going to be. I thought this was involving somebody else. I already represent Mr. Davis on some issues involved, but that's a different victim than the cases I have, so.
It's a new charge.
Yeah, and a different victim, so.
Okay.
I'm gonna sit back down unless you want me to stay up.
Well, stay close, because you're probably going to be.
I will.
on this one too.
Okay.
You understand-
I just had to get pictures last night.
I didn't understand what you said.
I said, I was a victim, I just had to get pictures last night. Him taking pictures in my arm.
I'll take that as a not guilty plea. Do you want a court-appointed lawyer? Mr. Steyer's here, I think he's representing you on some other things. Do you want a court-appointed attorney, Mr. Davis?
Yeah, if I'm not gonna be able to, I don't even get one,
I'm assuming are you working?
yes, sir, I'm working.
Where you work?
CNA research.
Are you getting paid by the hour?
I just, not really, I just make so much a week.
By the job, when they have work? Should have a lot of work recently, with all the trees down.
Yeah, I've been busy.
I think you were appointed before.
I'm appointed on other
Thank you
matters.
on this one.
Your Honor, we're already set for Friday on the other matters.
Well, this is a new ballgame, so what's the state's position on bond? This allegedly just happened today.
What is he in the court for already?
He has a variety of charges regarding with alleged victim Brandy Trailer. She's come in several times asking to have the charges dropped.
Yeah, I played just.
Sir, don't, sir, hang tight.
Yeah. So this Lindsay McMillan is Brandy's daughter, I guess.
Okay, I didn't realize that.
Yeah, I got my clothes back here too, it's soaked in blood. Even the gentleman said that my clothes are soaked. He's stitches in my arm. I had to call the police the other night, but there were 3 of them, now they're trying to fight you, now they.
Sir, I would caution you against making statements at this point.
Your Honor, the affidavit indicates that Mr. Davis was highly intoxicated, and I guess he's just recently been in treatment. And we realize that Ms. Trailer on the other charges has insisted that we dismiss the charges, but sometimes there's a good reason not to, even if the victim wants it.
She may not be of the same mind now.
Well, that's exactly right. So we feel like this is a situation that would require a cash surety bond, or I don't know what his history and treatment is, whether that is through this court or on those other cases.
It'd be on that other case.
He went to OVP in connection to one of these other cases.
Brianna's indicating
Yeah,
this.
no, fine, I'll do good.
Yeah, Your Honor, he recently completed OVP Recovery Center, and he was scheduled to continue with outpatient in Huntington, but he hasn't been to court since then. It's coming up, so.
Yeah, I think we intended to set the next hearing soon after completion of the expected completion date of the inpatient period. At this point, Your Honor, I would ask, we've already got him on the docket for Friday on the other matters. I would ask to set this for Friday as well. If he posts a bond, obviously he needs to be here. I'm assuming I guess I'm getting ahead of myself. We would ask for an OR bond.
Okay, I'm going to set his bond at $1,500, cash or surety, with a protection order to stay away from Lindsay. Is it her last name, Trailer?
McMillan.
Lindsay McMillan. Do you have another place to stay, Mr. Davis?
Yes, sir.
No?
Yeah, I think he said yes.
Where would that be?
I can tell you, my grandma was on all around, and I got multiple places, like I said.
Where are those located, though?
Grandma lives in Iron, my mom lives in South Point, way down in South Point.
Okay, that'll be fine. Your order to stay, if you post bond, but I'm going to require a bond because you've got so many cases pending, and I'm concerned you're not going to show up. So I'll set the next hearing for this
Friday the 3rd, Your Honor.
Oh, it's May 3rd.
That is Friday, though, isn't it? Oh, no, that's not.
It's a week from.
That's a week from.
Yeah.
Oh, that's a week from Friday. Well, what day is that?
His other hearing's set for May the 3rd.
So
It is May 3rd.
That's a week from Friday. I apologize, Your Honor, but I would still ask we set everything at the same time.
Do you think you can post bond? No.
I really don't want to entertain.
Well, we may need to go closer then.
You want to set it for Friday?
I am here Friday, so we might as well set it for Friday.
Hey, I got $200 in my property.
Well, you might be able to talk to Mr. Sowers about that and get out.
That should be sufficient.
And if you'd like me to, I'll call Mr. Sowers and ask him to come down there and talk to you.
Well, I mean, it's at the jail.
Well, you're at the jail too.
I understand that, but they're talking about having to write me a check and stuff for it, I mean.
Well, I understand that, but sometimes if Mr. Sowards comes down, they'll work with him, sometimes they won't, I don't know. And you might, or in the alternative, you might be able to sign that they can give that money to Mr. Sowards. There may be ways to work around this. I can't promise you anything, but it's a possibility. But just in case not, we'll set for Friday this week.
I'll put all his cases on this Friday, April 26th. Okay, that's all.
Thank you, Your Honor.
You're welcome. That finishes up at the jail.
Thank you, Your Honor.
Thank you. It's under okay. Back in December, whatever. You get a announcement, you're supposed to get
Oh, that's what you're talking about. State of Ohio recall Shannon Balls, case number TRC 194045.
Okay, let the state pull their file, and we're looking for the results of the toxicology report.
We have that, Your Honor.
All right, would you want to tell the results to Mr. Boggs?
The test results indicated positive for methamphetamine, THC metabolite, and amphetamine.
All right, so, Mr. Boggs, how do you want to proceed?
Not guilty.
All right. I'm going to place you in custody and up your bond. It should have been $2,500, so you owe another $1,500 in bond. You want to talk to Mr. Sowards?
Yeah, he's out. He's got me now on this, and the sheriff's department has my money. So,
do you wish to be considered for a court-appointed lawyer? Are you working?
yes, I could. I would talk to Butch Morford.
Well, that wasn't my question. Do you wish to be considered for a court-appointed lawyer?
No, I'd rather get Butch.
You're going to hire one? Okay.
Yes, sir.
All right. You can go into the holding cell and we'll get in touch with Mr. Sowards about posting your additional bond. I'll set your next hearing for May 6th. I don't think Mr. Morford's going to be here today.
He is not, Judge, I'm covering for him, but I'll let him know.
State of Ohio versus Wesley Earls, case number CRB 2497, CRB 2488, A and B.
Your Honor, Mr. Hill, I need to approach on this matter if we could.
Yes. She's back in. All right, this case is going to be recalled later in the docket.
Just hang tight for a few more minutes, we'll get it back up here.
State of Ohio versus Regina L. Hudson, case number CRB 23581, PRC 231382, A and B.
Mr. Steyer's case set for pretrial.
Your Honor, based on pretrial negotiate, and I think you may be aware of this, Ms. Hudson has some hearing problems, so Ms. Dalrymple, who is a relative of hers, has kind of stepped in to work with, make sure she understands what's going on. We are going to enter a plea at this time based on an agreed to recommendation for disposition. And this is a first offense OVI with a urine screen. The urine screen, we got the urine screen back some time ago. There's also a tail light or illumination of rear license plate charge. You're going to enter a plea of guilty to those. I think there may also be there's also a less than 100 grams marijuana charge, which I'm not sure if the state is looking for a conviction on that or not. We haven't really discussed that.
We would nolly that one.
And what we discussed was a global resolution of 20 days in jail suspended to the 3-day school, 5 days community service, a fine at the court's discretion, costs, and a 6-month driving license suspension. This case dates back to September of last year.
Was this marijuana metabolized, THC, was that what was?
Yes, Your Honor. We can get driving privileges, so you can drive for purposes. And we would be seeking driving privileges on that, and proof of insurance was shown at the time of the stop, Your Honor.
All right. Ms. Hudson, anything you wish to say?
No. No, I'm good.
All right, and you agree with what Mr. Steyer's represented to the court?
Do you agree with what he said?
Do you agree with what I said?
Yes.
You get on him?
Yes.
I'll impose a $400 fine, order the cost be paid, 6-month license suspension starting the date of the offense, 20 days in jail, all suspended, 5 days of community service, 2 years of probation, level 4. Review hearing is October 21st. She has to go to the driver intervention program.
That's the date you got to be back here. We'll talk more about that, but you need to have that date written down.
And on the CRB case is dismissed, 23-581 is dismissed. On the white issue, $5 fine. She's to see Mr. Major before she leaves. There will be a program here in Lawrence County starting June 1st for dip school.
Go out. Yeah, you go out in the lobby, I'll come out in a few minutes.
Thank you.
Don't leave till I speak to you, please.
Okay.
State of Ohio versus Richard M. Nance, case number CRB 24151, TRC 193086.
Mr. Steyer's case set for pretrial. My notes where he was at PATH.
Disorders.
PATH is recommending substance use counseling.
Do what? PATH said that you don't, PATH said you don't qualify for mental health counseling, but they think you need substance abuse counseling, but they don't provide that. So they're basically saying, we can't do it for you. What kind of insurance do you have? What kind of insurance do you have? Do you have a medical card?
Yeah.
Is it Medicaid or Medicare?
I don't know, Medicare, I guess, I don't know.
Okay. I vaguely remember, and he's saying he thinks he has Medicare versus Medicaid, and I'm not 100% certain of that, Your Honor, but I kind of remember that.
Social Security disability.
Do what?
You're getting Social Security disability?
Yeah, which I think was part of our issue, I'm sorry.
That would be Medicare.
Right, I think that was part of our issue before, but PATH was able to accept that, but I don't know.
OVP can accept.
Who among, okay. Well, Your Honor, I think the state is interested in seeing an assessment by a substance abuse agency. I don't know what the court's position is. I would assume that would also be the court's position.
Yes.
I think at this time, we might want to come back fairly quickly, get an assessment done, come back fairly quickly and see where things are, and then regroup and decide at that point what we're going to do. But I don't know, you said you're not generally setting things before the 10th. I don't know if you want to wait that long or not.
Oh, that would be fine. And
Okay.
That's for some.
I don't know a reason to be faster. I just didn't want to say, I didn't know 3 weeks was too long to ask.
So I would ask Mr. Nansen to meet with Ms. DeMint and get things started with OVP.
Our Mondays
For
are
an
Fridays
assessment.
for you?
Come back May 10th.
I'm here on that docket anyway, Your Honor.
May 10th will be his next hearing. Okay, and he has an old case, he still has community service that he owes on his 2019 OBI case. He still has 54 hours of community service.
Have you done any community service for here?
I've done a lot of community service.
Since we were here last?
No.
Okay.
When I was in rehab, they took me to Huntington City Mission up there to the community center all the time. I went on
Which
a walk.
rehab were you at?
And on Big Brain.
I need to know a name.
I don't know, can't think of it.
Okay. There's a possibility, there may be something we can look at getting him credit for, or not, I don't know that, but I'm going to have to do a little bit more research, Your Honor.
May the 10th for all his cases.
Thank you.
We're taking me to do previous work. I done them.
We'll talk about that there in just a second.
Your Honor,
Yes.
on the case we had previously, Mr. Summers,
Yes.
that Mr. Nash was representing him on the cases. He indicates that he's not representing him on the telephone harassment charge.
Okay.
All right, are we done on this? Your Honor. Oh, thank you.
State of Ohio versus Felicia R. Batu, case number CRB 24143.
Cross-filing Ron with
Mr. Green?
Jermaine, Nakia Jermaine. German, yes. It's a Butch's case.
State of Ohio versus Nakia German, case number CRB 24144.
All right, I set this quickly from Friday because Mr. German was being asked to move out. Did that happen? Okay, no problem? Good.
Everything's fine, Your Honor. I believe we just set it out 90 days. I believe that's what the prosecutor has agreed to.
So we're going to go out 3 months. If there's no problems, then it'll be dismissed. Is there going to be any cost assessed?
We'd ask for one cost. We'd also ask for the defense attorneys to fill out the continuance forms.
I don't mind doing that. And Judge acceptable, Mike, or Mr. Morford's client, Judge, we've discussed that possibility. He's on board with that. He'll pay the cost.
Okay, we'll be on Mr. German's case. So that's going to be July 22nd or 26th. Any preference?
No preference on Mr. Morford's behalf.
Either one is fine.
July 22nd. It'll be right exactly 90 days.
Oh, Your Honor, I'll be out of state on the 22nd, I'm sorry.
26th?
26th, yes.
All right, July 26th. It's a Friday, July 26th. And cost will be on Mr. German.
Bring it that day, you're done. You'll be dismissed.
Okay,
Thank you, Judge.
that's
Yes.
all.
State of Ohio versus Krisha B. Malone, case number CRB 23455.
Christian Warren, she's been here.
She's here. She's here.
Set for pretrial today, it's Mr. Smith's case.
It is, Judge, may I approach with a letter?
Yes.
Your last session was on April 15th, that means you're done. Yeah, the last time we saw him.
Ever get the file out?
Are you still going? Okay.
Have you seen this, Mr. Ely?
Which case is this? I'm sorry.
Christian Warren.
Take that. Judge, and the understanding was that this would be dismissed if she had an anger management assessment. Looks like, and I wasn't sure to interpret that her last session was on April 15th. That wasn't her final session.
I have an appointment tomorrow next week, no.
So she is still seeing this group for therapy. I don't know if we can go ahead and dismiss now because she's been there for 9 months. And her mother was the complaining party. We agreed way back when to a dismissal if she did what she's supposed to.
So it sounds like she's engaged in the counseling.
She has been for 9 months.
And it's continuing. My mother said she was going to be here today.
I take it she's not here?
Have not seen her.
Either one of my parents are here.
State want to try to get in touch with the complaint parties?
We have, just here the last day or two.
I was just with them the other day. She's been calling me.
We'll find out.
Oh, that's this case. Okay. Yes, we have spoken with her. She couldn't be here today because her husband had a doctor's appointment. There's been a history of Ms. Malone's parents wanting to try to mend their relationship is what it looks like to me, and she's been allowed to go to their house, and then something will happen, and then they want her out again, and they kind of make complaints that she's violated the protection order, only they were the ones that invited her there. And I understand she's their child, and so it makes it difficult.
My dad and I were sharing the lawnmower. My mom invited me into the room and was brushing my hair.
Okay, hang on a second.
And we understand that those things have been happening, which makes it a challenge to make sure that this young lady gets her counseling the way that we intended with the original orders for her to stay away when she's being invited there periodically. Her mother indicated to Jasmine the other day that she was okay if we just went ahead and dropped the protection order. She also said it would be okay if we dropped the charge. I guess in reading the report, it doesn't really indicate that she's reached some level of completion. It does say she's involved, and I believe she just got done saying that she was going to continue.
She's got an appointment next week. This is going to be an
I have
ongoing.
an appointment tomorrow and next week. Okay. I'm going because I have a broken heart.
Okay, I understand. We wouldn't oppose a dismissal, Judge, upon payment of court costs at this time, and it sounds like it's going to be an ongoing process. We could be here for years, potentially.
And that's
if the victim's on board.
I think it may be that we've done what we can do.
I take it that state's agreeable to a case being dismissed on payment of costs.
I believe so, yes, Judge.
Be dismissed on payment of costs. See the card.
I can go home.
Yeah, we can get court
What does my court cost, please?
$135.
$1,035?
Yeah, $150. Could you pay it today?
I think so. I'm struggling today, as you can see. I think I can.
Give her a final pay date just in case, Judge. How do you want to do that?
Give her another court date.
Sure. Well, just give her another court date. And before then, you don't have to come back.
May the 10th, if it's paid before then, she doesn't have to appear.
Good luck.
Thank you.
You're welcome.
Thank you, Judge.
State of Ohio versus Crystal Gonzon, case number CRD 23604, CRD 193957, A and B.
All right, this is normally Mr. Morford's case. He's sick today, so Mr. Smith's stepping in for him. She's asked on camera. Yes. Report.
Yes, Judge. I'm standing for Mr. Moore. She's asked about the possible removal of the hand from water. I see she'll be able to seek employment here in a couple of weeks.
Correct.
If not today, maybe.
I've been on it 5 months, and it's kind of hard to participate in the program because
Well,
it's so many requirements.
You started this one, though, April 5th.
Yeah, but I haven't ran anywhere in 5 months. And I ain't going anywhere.
Okay, good. Let's finish the program.
With the monitor?
Finish the program. So you're going to be able to get a job May 5th, is my understanding.
Yes, sir.
That's what it looks like, Judge, yes.
And she still has an ankle monitor.
She does.
Since you just started at hometown, I think we need to keep it until the next hearing. Let's set it for May 6th, or you
Oh,
can't do May 6th?
no, Judge Garrett's, Butch's case, he can.
Okay, May 6th.
Anytime May 4th, yes, he can do it.
Okay, we'll look at taking it off May 6th.
I also would like to ask Your Honor, if I can do the program until May 6th, the way it is with the rules, like to be able to see my kids or to go out, as long as I have this on.
I'll leave that up to the provider.
Okay.
Yeah, we can talk about it.
Okay. May the 6th is the next hearing.
Thank you, Judge. Yes, 10 a.m. May 6 at 10.
Your Honor, the prosecution has requested that we call Troy Houchins, case number CRB 22732.
Okay. Troy Houchins.
Your Honor, this is one that we received word from Mr. Anderson that we were to nollie that charge today.
Okay. This is an old case. Nollied on state's motion.
State of Ohio versus Stephen R. Scott, case number TRC 2489.
This is one of Mr. Morford's cases set for pre-trial. Mr. Smith is standing in.
Your Honor, Mr. Scott has been compliant with treatment. He showed up for all of his drug screenings and he's starting to engage more in treatment.
Okay. So you want to continue?
Yes, Judge, if that May 6th date works or any time thereafter.
Let's make it May 10th.
We can do that.
May 10th for the next pre-trial, 10 o'clock.
Thank you, Your Honor.
You're welcome.
See you then. Good work. Thank you. Yeah.
State of Ohio versus Caitlin Moore, case number CRB 2482, CRA 242410.
It's Mr. Morford's case set for pre-trial, and there's a new charge.
Yes.
This is a different date than the prior charge.
Apparently it is, Judge.
Week later.
Judge, we waive reading and are not going to play on behalf of Mr. Morford's client.
Okay. Excuse me. I'm kind of puzzled how we got to a burglary from what's in the affidavit.
Unfortunately, I can't help because this is the first I've met Ms. Moore.
Yeah, that's the affidavit from the other charge.
Okay.
there's an allegation that she kicked in the door at the residence, which is not her residence. So we're going to have to, okay. I don't know if we've attached the wrong affidavit, we need to get a different affidavit, but the police report discusses that happening.
Was this the same date? Because it looks like the prior charge, I thought it was February 7th or 8th, something like that. It's a different date. Yeah, February 7th. The date on the other charge.
All right, so we intend to Your Honor, this burglary charge, in the police report, there is a description of an act of burglary. However, this affidavit is the incorrect one. So we're going to have to dismiss this, and we're going to have to fix it and refile the case.
Okay, so 24-214 will be dismissed.
Is it 214 or 219?
Well, on the file it says 214. On the pleading is 219, so we got a scrivener's error.
Okay.
219. 24-219. Anyone know what a scrivener is? Mr. Smith is old enough.
Well, I've got white here, I do.
Used to be, that's the way everything was taken down by a scrivener. Everything. There was no typing, no computers, and scriveners. But I think that even predates our time.
I did a little bit.
Okay, but 24-219 dismissed by the state. No. Which means with the right to refile.
Yes, sir.
So how do we want to go forward with 24-82? Just put it out there?
I assume put it out there, Judge, have Mr. Warford speak with her. She's going to get a hold of Susie, make an appointment at Butch's office. And anytime May 6th or thereafter, please avail this.
May 10th is better. Is that?
I will tell May 10th, yes.
May 10th.
Yeah, Susie said anytime in May would work.
Be the next hearing for 24-82 for pretrial, 10 o'clock.
State of Ohio versus David L. Wilson, case number CRA 24178.
Take these, that's yours. Take these, Susie should have a copy. We're good to go.
Mr. Morford's case, pretrial. Mr. Smith, Andy Manning.
I didn't hear, which case was this, Judge?
David Wilson.
Yes, he's Mr. Wilson.
This is one where he's got to appear in Franklin County.
Yeah.
Did you appear in Franklin County?
No, they said he is court date is June 6th.
Do you think the warrant's been withdrawn?
Yes, right here, I got the paper.
Well, he's got a paper, looks like it's in really small font, I've got to find it. He says June 6th is his next court date. He has been in touch with Franklin County Clerk of Courts. Where's the date?
I have no idea, that's what they emailed. I have no idea, I don't know that stuff. But they said it in the sentence, so I don't know.
Did you have to post a bond up there? They let you
No,
sign a bond?
they just signed them. Yeah, they said, they have no warrant there, but I have a court date June 6th at 9 o'clock.
And I don't mind making a copy of this, Judge, for the court. Oh, here it is. You can hardly read it. Looks like he was in contact 4/16/24. There's a court date 6/6/24 at 9 o'clock a.m. in courtroom 70 there in Columbus.
Okay, here's what I propose to do. Let's set this for a hearing June 14th.
Okay.
And then if the warrant's withdrawn, he doesn't even have to appear.
Perfect.
If the warrant's still out there, you guys show up.
They said it's
Because he's got a bond up now, so. Just make sure that warrant's withdrawn and everything here will be taken care of. June 14th for pretrial.
Show up for that. You guys show up for that hearing.
Oh, yeah.
They borrowed for a second. I'll make a copy. I'll get back to you when I'm beating along. Okay. Thank you, Judge.
Thank you,
I'll make
Judge.
a copy of this for the court file. I'll see it. That's yours. That's your next date. All right. But then we can call the warrant so we're out of this hearing.
So you'll make a copy?
I'll make a copy. I'll see you in just a few minutes.
All right.
Yeah. I'll make one for you too.
State of Ohio versus Donnell Hall, case number TRD 24-610, case number TRD 22-175, case number TRC 21-371A, B, and C, CRB 21-103.
All right, Ms. Hall, do you have a lawyer then?
I do not have one yet. I just now got the funds to get a lawyer, so I haven't been able to pay one yet.
But you're,
I'm in the process of getting one, yeah. I just got the money together yesterday.
okay, so you're gonna hire lawyers?
Yes. If you don't mind to give me just a little bit more time.
How much time do you need?
A week will be fine.
Well, we'll give you more than that.
Okay.
Let's make it May 10th, that's the first.
May
date.
10th?
It's not terrible.
Okay.
May 10th.
Okay. At what time? 10 a.m.?
10 o'clock.
10 a.m.? Okay. Thank you.
For pretrial.
State of Ohio versus David L. Mills, case number CRA 24-9 and CRB 23-758.
Mr. Smith's case, preliminary hearing
Yes, Judge.
and pretrial.
Very good report.
He's at RRS.
Bobby.
Hey, Roger.
I agree with that, as long as they get the rest of my stuff in the phone, she took it now. Yeah.
He's got it. I think we have this resolved, Judge.
Okay.
I need a copy then.
Yeah.
I'll make another copy.
You do know they're trying to charge me $150 for a government vote, right? Yeah, included.
Judge, my understanding that we've had plea discussions, the felony would be dismissed. That's the disrupting public service charge in return for a plea to the domestic violence charge. There'd be a 30-day jail sentence, all of which would be suspended. A fine at the discretion of the court cost, and my client has agreed to pay $150 for the broken cell phone.
Mr. Gill.
And the victim in this matter is in agreement with that. The no contact order would have to be signed. Who would ask for that? And we're in agreement with the rest of what the...
He'll sign a no contact order, Judge. That's fine.
All right, and ma'am, you're Bobby Joe Hoffman?
Yes.
Okay. Do you have anything you want to tell me about this before I conclude the sentencing? So you do want him ordered to stay away?
Yes.
And there's no, you don't have kids together or any reason he has to be around?
No, but did I have my son also put on the order that lives with me? Because
Well,
there was a lot of conflict there too.
I'll just say your family.
Okay.
Is your son an adult or a minor?
He's a minor.
Okay, yeah, that's fine. So 24-9 is going to be dismissed. Molly?
It says you're going to stay away from that.
So we have to figure out how
And Judge, we're signing the no contact order. He's got a list of property, I understand. She's going to work on getting back. They'll figure out how to do that without him having contact with her, maybe a third party.
And bring it to RRS.
That's what she said.
Even better, too.
Yeah.
He knows not to go pick it up. He's not going to. Just sign it one place. Sometimes I sign tomorrow. Sometimes he has me say sign.
So he's pleading to 23,758.
Yes, Judge, the domestic violence, M1 domestic violence. In return for, we understand the state would dismiss the felony disrupting public service.
That's correct, Your Honor.
Was there any restitution owed on any damage to her property?
$150 to the cell phone.
Okay, that's right.
And he's agreed to pay that.
$150.
$150 for the cell phone damage that was broken.
Ms. Hoffman, anything else you wish to tell me before I conclude the sentence?
She picked up that one.
And Mr. Mills, you have a right to make a statement to the court if you wish before your sentence. Do you have anything you want to say?
Nah. I mean, I'll pay $150 for that government phone, just to get it over with.
Okay, I'm going to impose a $200 fine. Order the cost be paid. 30 days in jail suspended. Was there a recommendation on community service?
We didn't discuss
We didn't
that.
discuss it, Judge.
Okay, no community service. Review hearing will be, I'm going to order him to complete treatment at RRS. So come back for his first review hearing May 31st. May 31st, 9 o'clock is his first review. Order to complete treatment and to pay restitution of $150 for the phone. You pay that to the clerk, though. So
Okay.
the money you pay here, then she'll forward it on to you. We need, make sure we got an accurate address for you to send it to. 2 years of probation, level 4. I think that's everything. May 31st, 9 o'clock is the next hearing.
What's the case number on the misdemeanor, Your Honor?
23,758.
Thank you, Judge.
You're welcome.
So do I get a report on that?
Before you leave, there's John Major and probation is all here with that.
State of Ohio versus James C. Skipper, case number CRA 2478.
Sir. He's inpatient, he's put away. OBP, got a good report from them.
Yes, Your Honor. He has completed the program and he is due to continue to Shawnee Counseling Center for long-term treatment, I believe, tomorrow.
Okay. Now, is this Shawnee here or Shawnee in Portsmouth?
The one in Portsmouth.
Okay.
I don't think
Usually
Leslie's here
Leslie's here, but I don't
today.
think
Yeah, I haven't seen her.
Okay. And that's going to be, is that going to be on an outpatient or inpatient basis?
Inpatient.
Okay. And you know where to go to?
Yes, sir, I do. Yes, sir.
Come back in about a month and get a report?
Yes, sir.
I'm here the 20th.
May 20th is good.
I'll write that down. Just
Next
there on
hearing,
here.
May 20th. Expect to get a report from Shawnee at
10 o'clock.
10 o'clock, May 20th.
All right. Thank you, Your Honor.
Thank you, Judge.
Good work.
Thank you, thank you, sir. It's ridiculous, it's fine.
Finish that.
State of Ohio versus William Smith Jr., case number CRA 23327 A and B.
May I first, Your Honor?
Yes. Smith is at Bethesda. Excellent first work. Couldn't get much better than this. Good job.
Thank you. Thank you for help letting me get there. Thank you.
Thank you for taking advantage of the opportunity to do it. He's in sober living now, and he's basically running the sober living house is the way I take it, so that's good.
Can they afford to get rid of him at this point?
I think they can.
He's doing good, he's helping other people, it sounds like.
He probably wouldn't get the charges were dismissed anyways. I think he kind of likes us.
I do. Yeah, enjoy it.
Well, do you think it's time that we?
Well, there have been discussion that if with another good report this week, there might be a possibility of a dismissal. I think that's a really good report. So it's up to the state to make that motion, I guess, at this point, but we would join it if it was made.
It's hard for me to let go sometimes, Your Honor. especially if we're doing so well.
I'm sticking with the
So he's gonna
cigar.
stay with it, so I guess he's reached a level of trust that he's gonna maintain his sobriety forever.
Absolutely, we
Yeah.
completely support dismissal, yeah.
We're okay with the dismissal today, Your Honor.
Congratulations, Mr. Smith. Really good job. Keep it up.
Good work.
The work's not over. You don't have to come to court. You can come if you want to visit, but you're not required to come back. So,
Hey.
congratulations, your case is dismissed then.
Thank you,
Thank you,
sir.
Your Honor.
Good job.
Good work.
State of Ohio versus William E. Hall Jr., case number CRB 23204.
Oh, just a check.
Powers to this case.
All right. William Hall Jr. has a bond up. He failed to appear March 15th. I set it for a bond forfeiture. Mr. Sowers is out of town, so I'm going to assume he wants a continuance. So let's continue it to May 10. And give me a second to text him a copy of the charges and bond.
Okay, so I think it goes to the clerk. Okay. Because it goes, it gets, whatever. I never know where those things go after they leave me.
Okay, so I'll set 23-204, 23-229, bond forfeiture hearing May 10th. I've notified Mr. Sowers.
State of Ohio versus Dylan T. White, case number CRC 23-1818, A, B, and C. Dylan White.
Madam President.
Yes, this is Mr. Delauder's case set for sentencing.
Judge, I talked to Mr. Hill about this during pretrial conference. This is a situation where we originally contemplated if Mr. White could demonstrate to the court his willingness to work toward dealing with alcohol issues, the state may agree to recommend treating this as a unaggravated first offense for sentencing purposes. I don't know if Mr. Hill's prepared to do that at this point. I would like, in light of the most recent update, to suggest that we go ahead and conclude the case and make it maybe a term of Mr. White's probation that he continue his treatment. My understanding from speaking to him is that he believes he has kind of completed his treatment, but he's still going there on Mondays for meetings. He feels like that they're voluntary at this point and that they aren't being required of him, but he goes every Monday anyway.
Do you have a written report?
What's that?
Do you have a written report?
Yeah, I gave it to you. Here's another one.
Oh, yeah. Well, they say he completed the 12-step program. We would not have an opposition if this was treated for purposes of sentencing as a low score and giving credit towards the recovery program that he's done, but give him a suspended jail sentence and probation and make sure that he follows through and doesn't have any relapses.
Okay, I would agree with that if he passes a urine screen. So I don't know where he wants to do that. He's going to have to do a urine screen, and I'll sentence him after I get the results.
No problem, he says.
Okay, go do the urine screen, come back.
State of Ohio versus Michael W. Brzezinski, case number CRB 24176.
Yes. Since he is, so he outpatient, or supposed to be.
Yes, he never reported for his assessment, Your Honor.
Okay, he failed to appear. So there will be a warrant issued for failure to appear.
Thank you, Your Honor.
Thank you.
State of Ohio recalls James G. Adams, case number CRB 24130.
Mr. DeWaters' case, pre-trial.
Judge, the other folks that we needed to get in touch with are unavailable today, so we made progress on getting this resolved. If we could come back on either the 6th or the 22nd of May, I think we'll be done with this one. Or, I'm sorry, 20th, not 22nd.
20th.
20th.
May 20th will be the next hearing. 10 o'clock for pre-trial.
May I approach, Your Honor?
Yes.
When we come back,
20th.
May 20th.
did we do an interview?
State of Ohio recalls Wesley A. Earls, case number CRB 2497, CRB 2488 A and B.
Mr. Steyer, please.
I stepped out and spoke to Mr. Earls not too long ago. He was here. Okay.
So the neighbor, I can get all that, and I left him a
But it's also,
Do you have any word from the state, from the complaining parties?
one of the complaining parties we were able to get a hold of, and he says there's been no problems. We haven't heard from the other one, who is the actual right next door neighbor, but at least we have that much information.
Well, under that circumstance, why don't we continue it out for a little ways and see how things go, and then we can maybe make, after things calm
Right.
down a little bit even more, maybe we can make some decisions. about it.
That seems like it might be the way to go, Your Honor, at this point. So,
May 28th, that's a Tuesday.
May 28th, is it Tuesday?
Yeah, Memorial Day is the 27th.
Oh, gotcha. I'm available, Your Honor.
May 28th will be the next hearing.
Thank you. You want to write that down? May 28th,
That's
10
a
o'clock.
Tuesday, not a Monday. It's
Right.
Because of the holiday.
Thank you.
State of Ohio versus Charles H. Dennison, case number CRB 23566, ABC&D.
All right, Ms. Justice is here today representing Mr. Dennison. Do we have any word from the Court of Appeals?
Not yet, Your Honor.
Mr. Hill?
Well, our position remains as it was when we spoke about this last week. I think no answer may be an answer from the Court of Appeals, and I think the court already has said that that was the final order. At least that's what Your Honor indicated last week, so we agree with that.
Ms. Justice?
Your Honor, we're looking forward to hopefully hearing from the Court of Appeals soon and understand. We did not come back here today to rehash what the court made clear on Friday.
All right, I'm going to order Mr. Dennison into custody then. There's not been a stay issued by the Court of Appeals, so the prior order of this court will go into effect as I ordered, and if they issue a stay, then so I will obey that stay and lift any jail sentence. This time he's committed into the hands of the sheriff.
Love you, Charlie.
I love you.
Love you. We believe you. We know you didn't do it.
State of Ohio versus Chase W. Rickman, case number CRB 23525 and CRB 23650.
This is Mr. Spires' case.
What was the case you're on?
Chase Rickman, they had failed to appear before.
Oh, okay, I wasn't aware that it was happening to them.
March 25th, and came in today. Looks like,
Let me take a look here, hang on a minute. Yeah, give me just a second.
I don't see a bond posted, so I'm assuming they was not arrested.
No, it sounds like he realized that there was an arraignment and then appeared. We did have a case, we had this case set on March 25th.
Correct.
And that's the last note I've got. I don't have my file with me.
You want to take a close file, talk with him?
Yeah, if I can do that, Your Honor.
Once you're ready to do so. You're welcome. So the only thing we've got left is a urine screen on Dylan White and Chase Rickman. So the court will take recess until those are ready to dispose of.